I'm loading with coffee.
That's the only way to do it. What happened to our crowd?
Okay, let's call the meeting to order. Second day of the corporate joint interim corporations committee in Evanston. I see we're joined by Senator Barlow. Welcome. Good to see you, Senator Scott, online. Anybody else online? Okay, our first topic for this morning is insurance, and we turn it over to the insurance commissioner. Make sure your mic's on. It's that green one.
There we go. Better? Great.
Much better.
Chairman Case Committee, I am Commissioner Jeff Root along with my deputy Tana Howard. From the Lander meeting, you may recall that we were looking to amend Chapter 44 of the Insurance Code, which deals with holding companies. Wyoming adopted the Holding Company Act back in 1991 and was amended in 2013 and again in 2019. The act gives our department better oversight of insurance groups. And so you're going to hear some phrases. One is the insurance holding group. And all that is several affiliated companies, one of which is an insurer. And the reason for this oversight of these groups is to prevent one of these companies that's affiliated with an insurance company from siphoning off any funds that the insurer has.
Commissioner, could you pull that mic just a little closer?
Will do. Thank you.
Thank you.
So insurance companies have a lot of liquidity. They have to pay claims. And when they're closely affiliated with other companies, we want to be sure that none of that money is leaving inappropriately and leaving them at risk. So we always assess their capital, and this is something we want to do. Instead of just focusing on one company, now we're going to look at those companies that are affiliated with the insurer. So therefore, the Holding Company Act would give us the authority to monitor and approve transactions where funds may be going from the insurance company to another company. These changes and the entire Holding Company Act are an accreditation standard. Those standards were developed by the states and industry to ensure there's consistent uniformity among all of the states when we're looking at these insurers. At the Lander meeting, we presented the model law, and some of the members of the committee had some issues with certain parts of it. One part was rather notional and directive to the Department of Insurance, something that you wouldn't normally see in the statute. And I think Senator Barlow asked if that was something that would be more appropriate for rule. I raised that question with the NAIC, and they said that would be fine. I can do that. And so that has been taken out. There's another section in the Model Act that was it was awkward. It was just a really long run on, if you will, page and a half. And LSO, we talked with us and we looked at the other states. We looked at 6 or 8 different states that have already passed this. They have broken it down a little bit differently. It's a whole lot more reader friendly. And we copied what another state did. And then I took the whole bill, sent it off to the NAIC, and they've looked at it and they said, this meets accreditation standards. As written, it is fine. And so that's what you have before us. So
Great.
So with that, I'll look at page 1. It's the introduction describing the bill. And then on line 11, it's referring to the new section that is created. And so this bill jumps right into it. This is a brand new section. And so I'll explain a couple terms as we go. The new section in the statute deals with what can and cannot be done with the information from the group capital calculation and the liquidity stress testing. You'll hear those terms throughout. The group capital calculation is sort of like what it sounds. We will be doing calculations on the group, not just the individual insurer, but we'll look at those companies that are associated with it. And then the liquidity stress test and the related information from that. What that really is the department doing modeling to see what effects certain changes have on an insurance company. But in this case, since we're looking at more than just the single insurer, we're looking at those surrounding companies that are affiliated. We're going to see what impact, for example, if a non-insurer is put into liquidation, what is the impact then on the insurer that they have a relationship with? So it's looking at the liquidity stress test is looking at more than just the insurer. So the first part of the statute, it deals with what we can and cannot do with that information. And if you look at lines 5 through 15, that's really just stating that the tests that we do, these are tests that the insurance department does to assess risk. It's not for public consumption. It's not for anybody else to worry about but us. We're looking to see if there's a problem with the risk in this company. We're not racking and stacking or rating insurers saying this insurance in this insurer got this score. They're better than this insurer that got that score. We're not doing that. We're just looking at the potential risk. And so in that section, it references that this information shall not be made public. And it goes on to specify, and this is where that run-on page and a half goes, to specify all of the various ways that the information shall not be released. And they are very explicit in that. And this is what we took from another state. So looking at page 3, lines 1 to 14, you can just look through that briefly, but it's, you know, the information isn't supposed to be posted anywhere in magazines or newspapers or anything like that, or advertisements or announcements. Line 16 to 18, it states that if there is a prohibited release, it's deemed misleading. And I think this is there just to show, to emphasize that these tests and this information is for our use to assess risk. No one should look at it and do any other assessment other than in the insurance department. On lines 20, page 3, going into page 4 to line 10, if the information is somehow released and it's materially false. So let's say it's the value, it's the current assets of a company. Let's say the company has, you know, $18 billion in resources, but somehow it's released that they only have 10. It's factually just completely inaccurate. We have the ability as a department to talk to that insurer and say, do we want to do a notice that you actually have $18 billion in assets? And then we'd probably put some language in there that no one's to glean anything from this other than this is a factual piece of information on that company. So there is that ability for us to work with an insurer to do a targeted release if something is materially false. So, going to page 4, lines 12 to 16. This is really just the reorganization and the creation of a new section. And looking down at line 22, this is where you'll see the definition of group capital calculation instructions. So this is what the insurers will look at and what they'll have to comply with. And the definition of the instructions is the instructions itself. Going to page 5, definitions are continued here. On lines 15 to 23, we're defining the liquidity, the NAIC liquidity stress test framework. It's really defined as the publication and the instructions. It includes historical data. So from it, you could actually see what some of the liquidity stress tests were done 10 years ago, what the form looked like, and then 5 years ago. It has the scope criteria, which we'll define and talk about shortly. It has the instructions for the current year and the templates that they will use. So going down to line 25 and going into page 6, we're defining scope criteria. And all really this is the parameters in which the insurers know whether they have to give this information or not. For example, it'll say companies that have an assets above a certain amount, they must do it, or write so many premiums or have so many people covered, then they'll have to do it. It just sets out who must comply. On page 6, lines 4 to 8, it defines third-party consultants by the designated by the commissioner. These are just independent consultants that we would hire. This is a more accurate term that's already in statute, which just says affiliates, and it's not really as appropriate for this setting. Lines 10 and 11, we're just renumbering and including a new section 2244-120. So looking at page 7. So currently in statute, when an insurer is just is registering with us, they only need to provide what they say is material information. And this is very basic stuff. This is who you are, what's the structure of your company, what transactions are out there, what loans are pending, that sort of thing. And they say that, you know, they only need to provide material information. Well, when we do the group capital calculation and the liquidity stress test, we remove the term material from consideration. And I think that's because we don't want to get hung up on the technicality of what is or is not material. We're looking to assess risk. That's all we're trying to do. And if we want the information, we don't want to, you know, have a back and forth with what is or is not material. So. Let's see. Line 6 through 22, every insurer that's required to register has one ultimate person in control. That makes sense. We want to know who that one person is and they're responsible. And then the same thing occurs on our end. If there are multiple insurers in a holding company, they might be regulated by different states. there will only be one lead state commissioner. So there's one person in charge on both ends. So there's clear communication and who's responsible. Looking down at lines 21 to 22, we reference the holding companies that are exempt from filing the group capital calculation. So if you meet these exceptions, you don't have to give us the information. And you'll see from them, you won't have to give it to us because you've already provided it in some other way. So so looking at page 8, lines 1 to 4, if there's one insurer in a holding company and they only write business and are licensed in that state, they don't have to comply with this because the state already has that information. We don't need them to go to the effort to input the information again. On lines 7 to 15, if the holding company already provided the information to the Federal Reserve Board and the lead state insurance commissioner can get that information, that's where we'll get it from. We don't need the company to have to go through the steps to submit it. On line 17 to 21, if the holding company has already provided the information to a non-US regulator, so this would be a foreign country that's regulating this holding company in some manner, and it's a reciprocal jurisdiction, and they apply the same standards, we can get the information from them because it's a reciprocal jurisdiction. No need for the insurer to have to provide it. And going to the next page on page, it starts on 8, but going into 9, lines 2 to 16. This is a two-part exception. If the lead state already has the information and it's already been filed with a non-US group supervisor and they recognize and they accept the same standards that we have. If we can get it from them, we'll get the information from them and we won't have to have the insurer do it. So line 18 on page 9, and then this goes into page 10. It gives the authority to the lead state commissioner to require additional information. If they just see something that maybe isn't addressed in the instructions, but it's of concern, they can ask for that information. And going on to page 10, the reverse is true. If we don't need something and it's not necessary, we can tell them, don't bother submitting this, or we don't need this information. So it works both ways. On page 10, line 14 to 21, if an insurance company, holding company is no longer exempt, that means they'll have to file, but they have to file at the next filing date. On page 11, now we're looking at the liquidity stress test. Lines 1 to 8, if an insurer meets the filing requirements, they must file for that specific year. On line 10, on page 11, and this goes all the way into page 12, if an insurer meets the scope criteria for that specific year, so they have to file. It's basically just stating that that is the year they have to file for. If the criteria should change, the criteria won't go into effect until the following year. So no one mid-year is going to have to change course. Any changes will go in the future, and then they will have to apply in the future with those changes. It also states that if the insurer does not meet the criteria, they don't file for that year. And it gives the lead state commissioner the authority to determine if some information that might not be addressed is required, or if it's not needed either. So moving on to page 12, we're at lines 10 to 16. It states that the results of a specific year's liquidity stress test only apply to that year. And then at the bottom of 12, which is already in statute, we're starting to talk about the confidential treatment of this information. So on page 13, lines 1 through 14, that's already the existing confidentiality involving these tests. On page 13, lines 15 to 17, we're introducing a new section where the confidential treatment of the information and the data of the group capital. We're specifying the confidential treatment of both the group capital calculations and the liquidity stress test. And then going down to 19, this is just stating that the confidentiality and all the reported information is confidential with the group capital calculations, and it shall remain confidential. Page 14, lines 5 through 12, the commissioner maintains the confidentiality of the information of the liquidity stress test. And that's very important. It was something that was industry wanted. They didn't want other entities to have the information. So on lines 22 and 23, this is where we're starting to input, striking out the subsidiaries language and affiliates and putting in the third-party consultants designated by the commissioner. And let's see, on 15, stating that any, in lines 3 to 7, any of the recipients of the information, they agree in writing, it is confidential. And then the rest of the page is just striking out the affiliates and subsidiary and putting in the new third-party consultant designations language. Page 16, we're making the same strikeouts on the first half of the page. On lines 13 to 18, this is something that industry wanted, and it helps more tightly control the analysis that I talked about earlier that stays with the states. It prohibits the NAIC or the third-party consultants from maintaining the information in a permanent database. We will have it. The commissioners will have it. The other entities won't. Lines 20 on page 16 going into 17. If a third-party consultant is used, we actually disclose that information and their identifying information to the insurer. So in case they have concerns about maybe a prior conflict with that individual or something. And then on page 17, lines 5 and 6, we're adding the additional language for the third-party consultants. And then it's rulemaking and the effective date. And I know that's a lot and it's dense in a lot of areas, and I will do my best to answer what questions you have.
Thank you, Commissioner. Good job. Committee, questions for the Commissioner? Representative Ottman, we'll start with you.
Thank you, Mr. Chairman. Good morning. Thank you, Commissioner, for being here today. Just two questions to help me understand, because this is not my expertise, but on page 5 with the staff comment, if you could kind of go over what that means. And then I have another follow-up, if that would be all right.
Commissioner?
Senator Case, Representative Ottman, yes. So the staff comment, as I understand, I've seen these frequently from LSO, because some of our times we do reference the NAIC and what the NAIC does. And so we've seen this before. So there is a concern that you don't want to give up your authority in this room to someone out there outside of this state. In this instance, I don't think we rise to that level. And I think there's other instances where we haven't, and it's in statute. For example, we use mortality tables with life insurers, for example, and we've done that forever. And I can go back in statute and it actually will reference the mortality tables of in 1949. And they kept going back to the state legislature and updating it. And finally, 1980, they came in and they said, you will use the mortality tables of 1980 or the most current one in use by insurers, because it just made no sense. So I don't think it rises to the level where you're giving up control and your authority. I think it just makes sense that certain things are going to be updated, like instruction manuals each year. And we don't want to have to come back here and ask for, your time and attention to change something like that.
Representative Ottman?
Mr. Chairman, excuse me. So it's basically for updates then?
Mr. Chairman, Representative, yes,
Commissioner?
absolutely.
Yes. Mr. Chairman, follow up, please.
Please.
Okay, on page. On page 13, up there, line 3, it says shall not be subject to subpoena. Is that normal? I mean,
Give him a chance to get there. Commissioner?
Mr. Chairman, Representative Ottman, that's currently in statute. That's existing. And so then we're just adding parts below it. But generally the confidentiality of this information, that is the case. And has been for years. Yes.
But if anyone had a court proceeding and had a subpoena, they'd go to the insurer. They'd go to the source of the information rather than get it from our department. That'd be the most likely event. That's why we could protect it and not do harm in any way.
No, that's an excellent point, Mr. Chairman. I appreciate that. Yeah.
Can we revisit, who wrote the staff comment? Ms. Adams, you want to hit us on that? Would you mind? Sorry.
Chairman Case, Katie Adams, LSO. Yeah, that was something that just came up in our review and we just wanted to flag it for the committee's consideration as far as that being a potential question about whether or not that constitutes an unlawful delegation of legislative authority. But as Commissioner Rude noted, I think there are other places in statute where we've done something similar.
I certainly think so. I can think where we've made reference to federal law and said in statute something or subsequent law. This seems like it's almost the same thing, although it is NAIC, but I take it we don't really think this is material in any way. I mean, it's a fine point, perhaps. Okay. Thank you, Ms. Adams. Anybody else on that point? Senator Landon.
Mr. Chairman, just to add to your thoughts, it just seems to me like on education, for example, and in the transportation world, I'm looking down at the chairman. I think that there are references like this in our statutes. So I don't think this is too far out there by any means.
Yeah. I mean, you've got to be able to accommodate the evolving outside world without having to come back and be restricted. So I'm not sure if anybody has a better idea, we'll take it up. Thank you, Ms. Adams. Back to you, Commissioner, or back to anybody online? The bow tie senator. Welcome, Senator Barlow.
Good morning, Mr. Chairman. Good morning, committee.
Go ahead.
Good morning. Can you hear me, Mr. Chairman?
Absolutely. Go ahead.
Oh, thank you very much, Mr. Chairman. So on that point you were just making, Mr. Chairman, it seems like the highlighted language is what the LSO staff is referring to, if I understand kind of the context of it. And maybe the highlighted language is not even necessary because the first one says NAIC. So if there are changes, that would be the new guidance. So maybe it's just a small thing, but maybe that highlighted language is unnecessary. Just a comment. And then, Mr. Chairman, could I ask a question regarding page 5?
Absolutely. Go ahead.
Thank you, Mr. Chairman. So this is about how this information is released. I think it's actually, my apologies. It's
not page 5, but
yeah, it's not page 5. Sorry. It's about the release of information. So what my query is whether we should actually have a reference to the Public Records Act saying this is not a public record. And maybe it's elsewhere in the current statute, and I just didn't dig far enough around. But maybe Commissioner Rude could speak to that, whether we should actually have some reference to, if there isn't already, some reference to the Public Records Act. Thank you, Mr. Chairman.
thank you very much. They're conferring, Department of Insurance is conferring, and committee, I think Senator Barlow does kind of make a great point about the highlighted part on page 5. It says reporting template being as adopted by the NAIC. Well, even if they adopted a new one, it'd still be the reporting template adopted by the NAIC. So I don't really see the benefit of the language as amended from time to time. That just seems a little wishy-washy, but which point do you want to take up first, Commissioner? The public records or the?
Mr. Chairman, I guess on the public records, we have statements concerning public records throughout the statute and in a different section. In here, I think when LSO created this, they referenced what we already have, and then they talked about the new section. So I guess I'm not sure of the question in the sense that I think they've been clear in that we have these sections already, and then this is a new section that also applies to what we're talking about, the liquidity stress test and the group capital calculations.
So you're saying that the exception from the public records is probably already encompassed somewhere else in the law, in your
Yes.
statute. And then Ms. Adams is swooshed in here. Ms. Adams.
Chairman Case, so on page 17 in subsection G, I'm not sure if this covers all of it, but it does provide that documents, materials, or other information in the possession or control of the NAIC or a third-party consultant designated by the commissioner pursuant to this chapter shall be confidential by law and privilege, shall not be a public record under 16.4.201 through 205, shall not be subject to subpoena. I'm not sure if that covers everything in this, but it at least covers that part of it with respect to the Public Records Act.
And thank you, Ms. Adams. As I understand what you just said, that says anything the commissioner gives to the NAIC or these other entities is not covered by the public records. It's not clear to me that that actually says that what the commissioner has is not covered by but it must somewhere. It absolutely has to. And Ms. Howard is, she's nodding. I'm going to go with her. Here she comes.
Mr. Chairman, Dana Howard, Deputy High Insurance Commissioner. Yes, we do have some statutes, not specifically in this chapter, but earlier in the insurance code that protect financial information of our insurers that are completely confidential
Okay.
from those records requests.
I think we're covered, Senator Barlow. I definitely think so. Did you want to address the other point? That was, that we could take out and is amended by the NAIC from time to time because it doesn't add anything.
I agree it doesn't. In my interpretation, I think that is fine.
It's a model act and
It's a
NIC.
model act. It is. I would
Blah,
still,
blah, blah.
I'll still run it by them if you really want to go that way.
Okay.
But I read it the same way that you all do also.
Yeah, I understand. It's just fine point. Senator Scott is online. Senator Scott, please. Welcome.
Mr. Chairman, two things.
Yes, yes,
On
sir.
Can you hear me?
Yes,
Mr.
sir.
Chairman?
Absolutely. Keep going.
On the page 5
Yes, sir.
highlighted
We
language.
can hear you.
My prediction is that if you take that out, the NAIC will come back and say you're out of compliance. And the fear would be that without that language, some court somewhere would interpret it as having locked in the NAIC regulations as of the date of enactment. I think that that's there because of that particular fear, and I think they will probably insist on it. I could be wrong, but I would caution against removing that language. It does make it
Senator
clear.
Scott, I suspect that we're not going to fight it.
Yeah,
We're going to
Second.
probably take your counsel.
yeah. Mr. Chairman, second general question for the insurance department. Of our domestic companies that the insurance department is likely to be the lead on, are any of them going to be affected by this particular act?
Commissioner.
Mr. Chairman, Senator Scott, yes, we have two that this applies to now and will going forward. I may or may not be the lead state commissioner on some of this, but the
Potentially.
Holding Company Act applies to 2 of our 4 domestics, 5 domestics.
Yeah. The answer is yes, Senator Scott.
Thank you.
Okay, any other members? Senator Landon.
Mr. Chairman, thank you. Commissioner, I got lost a little bit in your discussion of the release of information. And I'm just trying to understand that a little bit better. If you could, first of all, how all of that is prohibited. But then we have a clause in here that says, if the information is released, we're just going to call it misleading. That kind of lost me a little bit. Can you help me with that notion? Thank you.
Commissioner.
Mr. Chairman, Senator Landon, I agree there's sort of a fine line you got to follow. I believe that this model law is written so that information should not be released. And the reason it should not be released is because we're just using it to assess liquidity. We don't want anybody to interpret that any way. We don't want anybody to say this company is better than that company because of this analysis. We don't want any of that. And so we say that none of it should be released. And then we say if some of that leaks out, and I think this was actually, there was concern that some companies might want a leak of this information to show how great they are and better than their competitors. And that's what the NAIC was trying to avoid. And so we want to be able to say it was a prohibitive release of information. It is misleading. And then if we needed, we could do a statement that says, no one is to interpret this as a positive or a negative against this company. They should infer nothing about this information because what you have seen is misleading. And then there's this third category. What if it's a leak and it's flat out factually wrong? And instead of a company having, $400 billion in assets, it reported they had 100 billion in assets, and their stockholders like, whoa, this doesn't sound right. We want the ability to at least head that off and issue a statement and say, this is factually wrong. They have 500 billion in assets. And oh, by the way, please don't interpret anything positively or negatively by any other information you might see regarding this company. And so that's sort of the line that I follow getting me through that, but it is somewhat confusing.
Thank you for that, Commissioner. It's helpful.
Thank you, Senator. Senator Boner?
Thank you, Mr. Chairman. I'm probably about to prove my ignorance in the insurance business here, but following up on that, what would prevent a company from just going out and saying that publicly, we have X amount worth of assets? Why? I mean, if it leaks from the insurance commission, does it give it more credibility? What's the nexus there? I mean, why would a company even go, what's the incentive for a company to use information they submit to you, leak it to the public when they can just go out and say whatever they want to the public, right? Or
Commissioner.
Senator Boner, there's information that is, might be given to stockholders and they see something and that's fine. But our analysis is what we're concerned with releasing. And quite frankly, I mean, if we found a company that intentionally did this, we have certain authority over them that we could suspend their license and say, you're not writing any more business in this state, or whatever. We could fine them. We could do a number of things. But there was such a concern that we didn't want a company to use our analysis in a positive way or a negative way against competitors. So.
Fair enough. Down here, Representative Haroldson.
Thank you, Mr. Chairman. Thank you guys for coming today. Just, I guess, and I'm probably going to show my ignorance as well, but starting on page 14, 15, and 16, where you strike out its affiliates and subsidiaries and then add in or a third-party consultant designated by the commissioner. Are we for sure, is that net going to catch? Because obviously we're eliminating maybe, I think, a little bit of a broad spectrum of affiliates and subsidiaries. And in some ways, maybe does third-party consultant cover everything that other would have covered, is I guess my question. And then there's areas where we're striking it, but we're adding in this third-party consultant in many more areas. So I don't know. Can you explain that a little bit? And again, just maybe a little.
Ms. Howard?
Mr. Chairman, Representative Haroldson, in working with LSO on some of this language early on, this was a recommendation from them because it's more accurate technically. As it says now, its subsidiaries or affiliates, these are actually not, that kind of reads as they're working on behalf of the NAIC. That's not who or we would be contracting with or hiring to do some of this analysis. They're actually third-party consultants that have these specialties that we as a department contract with. Does that help? Hopefully. Thank you.
And just the word subsidiaries sort of never fit, right? Because none of these entities can have legal subsidiaries in the sense that we think of them as a corporate subsidiary.
Mr. Chairman, that's right. And the reason it's still in there and should still remain in there is because, and I mentioned this in Lander, we're blending our standards with the European standards. So we get the European companies are more likely to come here and vice versa. So and somewhere else in here, it talks about commissioners or officials. They don't have commissioners in Europe. They have officials. And so that's why you see that language.
Gotcha. Thank you with that. Anybody else on the committee? Anybody else, the members? Senator Barlow, Mr. Bowtie.
Thank you, Mr. Chairman. So Mr. Chairman, my question is in the effective date. The effective date for, I think it's section 3 and 4 is the middle of the year, July 1st, 2025. And just based on the way insurance is written and that is a January 1st or a more appropriate date? Does that coincide with anything differently? I think this question has come up before, I don't know, in other settings. So I just want to know if that's July makes sense or if it should be considered also as otherwise. Thank you, Mr. Chairman.
And just to tag on to your question, but there's also rulemaking in there that will have to get done. So I'll yield to the commissioner.
No, Senator Case, I think that's why it's there is because the rules, believe it or not, take longer to get through sometimes than a legislative change to a statute. So we want to start right away if we can, I think is why that's there.
It won't, Senator Barlow, I don't think it'll actually impact anybody's filings until into 2026. Would that be right? And so, but they need to prepare for it is what they're saying.
Thank you, Mr. Chairman. I certainly thank you, Mr. Chairman. I certainly recognize the rulemaking process. 2025 general session ends, first part of March. Effective July 1st leaves 3 months, 3+ months for rules to be promulgated or emergency rules if the regular rules aren't there. So I'm just saying if it doesn't actually need to be in effect until the first of the year, then maybe the first of the years are more appropriate for lead time for rulemaking, et cetera. Just a comment. Thank you, Mr. Chairman.
And thank you, Senator. I think the fine point is that they'll actually start the rulemaking on the July 1st is probably what will happen. But we have done things where we've allowed agencies to make rules in advance of effective legislation. There's some wording we have used, but anyway, I don't think that's a big point, but you're welcome to pursue it later on. Anybody else on the committee at this time? Do we have anyone in the audience that'd like to testify? Please, Ms. Wilkinson, welcome. I got a feeling we're going to be nice, and then not be nice.
Mr. Chairman,
First time.
members of the committee, Catherine Wilkinson here on behalf of American Property Casualty Insurance Association, standing in support of this bill.
That's one.
It is an NAIC accreditation model bill, and it has been very well vetted, and we do support the passage of this bill. So I would stand for any questions. Thank you.
Thank you, Ms. Wilkinson. Any questions for Ms. Wilkinson? Thank you very much. Appreciate that. Ms. Shaner, are you offering any testimony? Thank you. Is there anybody online? Committee, you've heard testimony. What is your pleasure? Motion by Landon. Is there a second? Second by Boner. It's a Senate sweep. House members are sleeping this morning. Discussion. Are there any discussion? Any proposed amendments? Any proposed amendments? Let's have a roll call on the bill.
Good morning, Mr. Chairman. This is roll call for 25 LSO 0007.5 Insurance Holding Company Regulation Amendments. Senator Barlow,
Aye.
Senator Barlow?
Senator Boner,
Aye.
Senator Landon.
Aye.
Senator Scott,
Senator Scott?
Aye.
Representative Chadwick, Representative Haroldson, Representative Harshman,
Excused.
Representative Knapp,
Representative Knapp? Representative Knapp, how's minerals going?
I will text him and see.
We might get it. We'll leave it open. Okay,
Representative Newsom, Representative Ottman,
Aye.
Representative Wiley, Representative Yin,
Aye.
Co-Chairman Case,
aye.
Co-Chairman Olson,
Aye.
Let's leave it open. It's going to pass, okay? We are going to allow them to enter a vote. Commissioner, would you come back up and we'll just take up the next bill? Oh, we do. We have a lot of local talent here too. Welcome to both of you. Evanston is well represented at this meeting. And a former Secretary of State too. All right, Commissioner.
Mr. Chairman, Tana Howard, Deputy Insurance Commissioner.
Deputy Commissioner, how are you?
Great, sir. Okay, so we are talking about insurance amendments. And I will go through this bill. It's a lot more fun than the last one, I guarantee you. What we are doing on the first section, this starts on page 3. It looks like a lot of words, but really what we're doing is rearranging. We're not changing a definition. What we need to do is clarify the definition of insurance transaction. Currently, we have the term insurance transaction listed over 12 times in our code, and we get a lot of questions from industry and from agents of when to apply. What does insurance transaction mean? For example, we have a reference in our licensing code that says if you're licensed as an insurance agent and an insurance consultant, you can't act as both in the same insurance transaction. That has created a little bit of question of what is an insurance transaction? What does that mean? And we have a definition for transact. So what we're doing in this first part is just clarifying that. Insurance transaction, we do have a definition for, as you'll see on page 4. But as it's listed with insurance transaction, it only applies to insurance support organizations. So not exactly the situation or circumstance we need. What we need is transact, which we've already defined in the code. So we're just adding a subsection. All we're doing is adding that subsection B, saying for any other circumstance other than when insurance transaction is applied in an insurance support organization, it means transact. And that's already in the code within that XXX definition. Moving on, we go into 26.3.106, and you're going to see this reference or the strike through of original several times throughout this bill. When we license insurance companies, we give them a physical copy of a certificate of authority. It is their license. As it stands now, because it says original, we have to give them a physical copy. And if those insurance companies make changes, they have to send that back to us. What we're doing is trying to update the code, be more electronic friendly. We're still going to give them a paper copy of their license, but every time they make a change, they don't have to mail it back because within our code, we say this is the property of the department. So we're just updating this. We don't change how we're licensing companies, anything. We're just removing original certificate of authority. And that's listed several times, as you'll see on page 6. And then again, on the bottom of page 7. On the bottom of page 7, we're creating a subsection E. And what this is requiring is insurance companies to provide their contact information. We require agents and other licensed entities to update their contact information and provide it to the department. We haven't had a requirement for insurance companies, and that has created a burden for the department. If we have a complaint from a constituent, or we're just generally having a question about a policy, form filing, we would like to be able to get a hold of those insurance companies with the correct contact person and appropriate person. So we're requiring them to update their contact information within 30 days. The next section we go into on page 8, which is 26.3.122. We are changing registered mail to certified mail. Registered mail is this is the only last reference we have within our code. We've updated a few others within to reflect registered mail in lieu of, or certified mail, excuse me, in lieu of registered mail. These are legal documents that we're sending to insurance companies. We need to make sure they get them, but we feel certified mail is sufficient. We're not insuring anything. There's nothing of value. We don't need registered mail, and it's way more expensive than certified mail. So that's just an update to that.
And just housekeeping, remind us of the difference between the two mails. On one, they have to get the signature from the recipient. So
they will both require, Mr. Chairman, excuse me.
yeah,
They both require a return receipt. What registered mail, generally requires that there's insurance involved, that we're insuring what we're mailing. Because this is a legal document, we don't need to insure it. There's no value necessarily. Well, it could be a value to somebody, but it's not a value to the department. We're still requesting that return receipt process and confirming that they received it and who signed it and when we get it. We're just not insuring what we're sending.
Thank you.
Continuing on to page 9, this is a cleanup, a true cleanup. A few years ago, we brought this committee a licensing bill where we made several updates within Chapter 9. We missed 2 references from producer to licensee. So we're just updating those terms to licensee because these are a few that we missed. On the bottom of page 9, again, we're striking original just to remove that physical copy of certificate of authority. That continues on to page 10 and the bottom of page 10. Then on page 11, we're striking this last sentence, talking about a certified copy. Again, this refers to the certificate of authority and that formal physical piece. We're just removing that. Nothing is changing about how we're licensing those companies and providing them proof that they're licensed, just that physical copy. On the bottom of page 11, this is 2635-201. This is our cancellation and a non-renewal statute or chapter. What we're doing is that we're getting a lot of questions on our policy section of how this scope of the article reads. And it's creating a speed to market maybe issue with insurers where they're just questioning when the exemption applies for these temporary insurance. And so what we're doing is we're just removing, we're not changing how we interpret this law or the scope of it. We're just clarifying it because we get a lot of questions about this. So we're just striking through this reference of 2615-119 and personal lines policies. And what this is saying, that this piece is saying that if you're an insurer and you're canceling a policy, it doesn't apply, this chapter, this section doesn't apply to temporary insurance. So when you go and get an auto policy and they give you a temporary ID card for 30, 60, 90 days, obviously our 45-day cancellation period and those requirements aren't necessarily going to apply to a temporary insurance binder. It's going to apply to your actual policy. An insurer can't give 45-day notice on a 30-day temporary policy. So this is just clarifying that. Moving on to page 12, we have some repeals, and this is a lot of language. The first one is this 263113. This also talks again about that original certificate of authority. This is the piece where it says, hey, if a company changes anything, they have to mail that physical copy of certificate of authority back to us, and we're just removing that. Then we go into 2 references in 26, they're the same thing, in 2618-103 and 2619-107. This was, and it talks about adult wellness benefits. This repeal was brought to us by our domestic health insurer as a recommendation. And this is probably our #1 objection on or issue on health insurance policies because it just causes so much confusion. It's an outdated statute and we just need to remove it. What this does is adult wellness benefits are wellness benefits, and we, as consumers nowadays, they're pretty standard within our health policies. They're benefits that aren't subject to deductible. When this was written, this was a very new concept. This was, the best thing. Insurers were encouraged to do this, and it was telling them how to apply these benefits. This 80%, the 20%, right? Saying, we need to give notice and disclosure to consumers saying, hey, you have these adult wellness benefits. We don't call them adult wellness benefits anymore. Insurers have learned over the years that these are valuable products, right? These are valuable benefits. It works, and it's in an insurer's benefit to get their consumers to the doctor free of charge for their wellness benefits or to have those wellness checks. So these are pretty standard in the market. And so we're just removing this disclosure and requirement. We're not removing any benefits from policies. This is just removing the disclosure because it's creating a lot of questions. Questions from insurers. Why do we have to put a disclosure on here? Typically, when you think of a disclosure, you think of bad, like, hey, this may not be a great thing. But it's causing that confusion. Also, questions from insureds, consumers saying, what is an adult wellness benefit? Well, it's a wellness benefit. So just by removing this, we're just trying to update the code a little bit and clarify and get those policies reviewed and out to the consumers, speed to market for the insurers. And with that, I stand for any questions.
Well, that was funner than the commissioner's presentation, didn't you think, guys? Members of the committee, any questions for Ms. Howard? Any questions from the committee? How about online? We got Senator Barlow, please.
Thank you, Mr. Chairman.
Go ahead, Senator Barlow.
Thank you, Mr. Chairman. There's a little bit of a delay, so my apologies. So my query is on page 4 of the bill, 5 of the bill, I guess, the new language regarding insurance transaction. And when I look at the new Romanet A, capital A, it's referring, and the good deputy commissioner talked about this, back to the organizations. And so my query is, do these organizations only do insurance support organization, only do what is talked about in this, personal, family, household needs, and not do, and because it says primarily there. And so I'm just questioning whether we need an A and a B, or if we just need to make insurance transaction apply to everything carte blanche, because there is no really difference for this insurance organization. Thank you, Mr. Chairman.
Thank you, Senator. Ms. Howard.
Mr. Chairman, Senator Barlow, what is currently in subsection A on page 5, it is correct. Yes, those insurance support organizations are used in those personal lines types of policies. And these insurance support organizations could be like an underwriting type of organization where they, or possible, an organization or database that provides claims information, a driver's license record or whatnot. So yes, we do need that, and that is accurate. What we're just trying to do is add that subsection B saying, and this is insurance transaction means transact, and try to connect the two, because we're getting confused members of industry saying, well, insurance transaction only means in an insurance support organization. So that's not exactly correct. And we're trying to relate it back, in these circumstances, saying, well, actually transact, which is already in the definitions applies. So we're just trying to connect and clarify really the definition of transact, which also means in any other case, insurance transaction.
Senator Barlow, mulling it over.
Thank you, Mr. Chairman. I guess there are different, you go back and look under transact, there are different definitions and different things, and they're included under A of this one. So we don't need to exhaust it now. I'll follow up with the commissioner and the deputy commissioner, but if we want consistency, shouldn't it all be the same? Shouldn't all of these entities be under the same definition? Because to me, when I look at transact, it does not include benefit pay or payment or servicing of an insurance application. It's different verbiage up above. So anyway, all I'm saying is I know what you're trying to tie it together, but still we're creating an inconsistency between A and B, because A has specificity in it, B has a different reference for its specificity. Thank you, Mr. Chairman.
Yeah, and Senator Barlow, the entirety of A is basically old language. It's the existing one. And the commissioner, deputy commissioner feels that we need B because they've encountered things that are outside, that are not clear under the old language. And so it's kind of it's almost a fishing license, but deputy commissioner, have I got that right?
Yes, Mr. Chairman. And Senator Barlow, the current existing language in subsection A for insurance transaction is very specific to certain situations and circumstances. And an insurance support organization could not apply the functions in the definition of transact. The insurance support organizations are not going to perform insurance transactions that include solicitation, that are going to include negotiation. These are things that apply more to agents or the companies themselves and not the insurance support organization. So that's the reason for the two definitions. I completely understand that it can be confusing, and that's why we were trying to create that subsection B saying, right, the subsection A is not what we're talking about when we mean insurance transaction. When an insurance producer and a consultant are working for the same insured, they, in the same insurance transaction, they're talking about soliciting, negotiating, executing an insurance contract. When an insurance support organization is working on an insurance transaction, they are doing exactly what it's spelled out in subsection A, saying we're going to apply, we're going to help the insurer to rate these risks or to apply data for these policies. They do not have the capability or the authority within our code. Further up, we define insurance support organization. It's not listed specifically in here, but it is within the code, and I can read that. But they have specific authority and scope of what they're to do. And so we're just saying within those insurance support organizations, insurance transaction means this. So I do understand the confusion. I apologize, Senator Barlow.
Thanks a lot. Keep thinking about it. Got a thumbs up from Senator Bowtie Barlow. And how about back to the committee? Are there any questions from the committee? Looking down to the left, looking down to the right. Anybody online? Senator Scott's, Representative Knapp, you're welcome. Think we're good. Is there any public comment on this one? Thank you very much. Just smile. So enter that there's no objection from the floor on this bill. Is there anybody online who would like to testify? Committee, you've heard the discussion. What is your pleasure? Got a motion by the co-chairman. Is there a second? Second by Chadwick, and discussion. Any proposed amendments? Any proposed amendments? Hearing nothing, let's close it with a roll call vote.
Good morning, Mr. Chairman. This is roll call vote for 25 LSO 0008, version 7, insurance amendments. Senator Barlow?
Senator Barlow. I don't see him on the screen. We'll leave it open.
Senator Boner?
Aye.
Senator Landon? Senator Scott?
Senator
Aye.
Scott. Senator Barlow, do you hear me?
Aye.
Roll call vote. Okay.
Aye.
You got
Representative
Barlow?
Chadwick? Representative Haroldson? Representative Harshman? Excused? Representative Knapp?
Representative Knapp, if you can hear me. How's minerals going, Representative Knapp? We'll leave it open as well.
Representative Newsom? Representative Ottman?
Aye.
Representative Wiley? Representative Yin?
Aye.
Co-chairman Case?
Aye.
Co-chairman Olson?
Aye.
Thank you very much. Looks like a unanimous vote with someone hanging out there. So, and we'll leave that open. He can enter his vote if he wants. All right. Well, I guess we're done with insurance now. Is that right? Nothing left under the sun, except for we do have one more. Commissioner, let's go ahead and do it. Go
Mr.
ahead,
Chairman.
Commissioner. Oh, I'm sorry. Whose voice? Oh, it's got Ms. Howard.
Sorry.
I'm looking around the room saying who's talking to me. I'm sorry. Ms. Howard, Deputy Commissioner Howard, please go ahead.
Okay. This is an rate notification and rule filing requirement bill. We're really trying to do two things within this bill, and it starts on page 2. Right now, we are at, this is a rate notification requirement for insurers. So what we're asking is insurers to notify the department within 30 days if they are going to impose a rate increase of over 30%. We ran into this, just to give a little context. We had an insurer last year that imposed a rate change in Wyoming between 80 and 200%. And we have a department of 26 people, and they have this specific insurer had a pretty significant clientele in Wyoming, and we started to get calls. Wyoming does not have rate authority, to be clear. We consider the insurance market to be competitive, and so insurers can work out those rates. So we do not review, we do not approve any rates within property casualty. So when we started to get calls, our 26 employees, we received over 200 calls, emails, complaints. I have one person working consumer complaints for property casualty. That's a significant workload for that individual. So what we were trying to do, and it all worked out. We contacted the company and said, hey, is this correct? And we had a phone call and we worked through this, and turns out they had not had a rate increase in Wyoming in over 15 years. So it was warranted, and we understood that. And we were able to work through that with the insurer and get a specific contact information. So we thought it would be nice to know this ahead of time. It worked out well. We were able to field these calls and help consumers and get them a specific contact for that insurer. So what we're really asking for from the insurers is we're asking how many policyholders were affected. And that's because 10 policyholders are a lot different than 200, and especially in a department of 26. We're asking for the percentage, right? 30% is a lot different than 200%. So, and that we can anticipate the phone calls and the notification within our office. And we're asking for the effective date so we can prepare and know when is this going to happen? Is it going to be next month, or is it going to be next year, just to kind of prepare our department? The property casualty market, this would apply to all rural markets, but the property casualty market, as we all know and we've discussed in this committee, is a harder market today. It's tougher. Rates are going up. And as a department, we feel this is important to have a better understanding and a better watch over our market to know what's happening, to be a little proactive instead of reactive. This is not subject to commissioner approval at all. It's a rate notification only. We just want to know about it. We did put in a provision asking for anything else regarding if we need something. This is if the sky falls. For example, I know a lot of our communities are battling fires right now. If God forbid, we have a terrible fire within our state, we put in a catch-all if the sky falls of any information right required by rules or regulation. The intent today is that we do not plan on issuing a rule today. But in the event that our communities or a specific community had a devastating wildfire, we could implement a rule that would say we need the effective area of that, to add to the information that we're asking from the insurer. That would not change, that it's still just a notice, that it's not commissioner approval, but we may ask from the insurer the effective area, like, is this a town? Is it a county? Is it a half the state? So that would be an example. And that's really why, instead of coming back to the legislature and say, hey, we need more information here, that we put in that catch-all by rule. And we have done that in other sections of our code. There are several cleanup on page 3, just working with LSO on some clarifying language, removing provision and substituting it with subsection, nothing really substantive here, clarifying delivery or used in the state of what type of forms we're really talking about. And then we move on to page 4, and this is part 2 of this bill. Part 2 is requiring the filing of underwriting or business rules from an insurer. So currently, insurance policies in Wyoming, we are a prior approval state. So what that means is every insurer that has a policy in Wyoming has to file their forms with the Department of Insurance, and we have to approve them before they go to your door. So any form that you have received, your auto policy, your home, it comes to us first, and we ensure that it's compliant with Wyoming law. If it's not, we object. We say, hey, you got to change this language. And we work with the insurer and we get it out the door. what we're seeing is there is an increase of every insurance company has underwriting rules. So when you write your policy, it goes to an underwriter and they decide the rating, they decide what type of risk, they decide based off of all of these different rules. It's kind of it's unseen language that applies to all of our policies. Some of it is based just off of ratings. Some of it is more based off of policy coverages, but it's not something that you as a consumer or us as a Department of Insurance sees, but it's definitely something that affects the coverages and policies that go out to consumers. And what we're finding at the department from complaints that we've received, but also from companies who have inadvertently just filed their rules because they do so in many other states, that these rules are not in compliance with Wyoming law at times. So what we're asking for is a little bit more of transparency and to look at these rules to make sure that they're in compliance with Wyoming law. For example, we have found a rule from an insurer that has applied fees. In Wyoming, you can apply fees based off our insurance code. Fees are allowed, but they have to be included in the total premium. They have to be transparent and clear to the consumer saying, this is what my total premium is, including the fees. And we also tax that premium, right? So some of these underwriting rules are applying different fees that we're not seeing, which would be contrary to, and they're not including them in the total premium, which would be contrary to Wyoming law. There's other rules that are applying coverages. So you may think you have coverage for something, but necessarily the rule applies and you may not. Another law within Wyoming is our cancellation fee or our cancellation requirements for return of premium. If it's generally within the rules of how those insurers refund the premium. These are things that we're not seeing, we're not privy to. So we're just trying to make sure that they're in compliance ahead of time, proactive instead of reactive for these insurers, because we're definitely seeing a trend. The insurance department sent out a survey to several other states asking, do other states file rules? And we heard back from about 20 states, and they do in fact require rules to be filed. Most of these states, again, Wyoming is the only state that does not have any rate authority or rate filing requirement. This is not a rate filing requirement. Often rules, and neither is the part one of this bill. Often the rules are related to rate, but we're not asking for the rates. We're only asking for the rules to be filed. And often these rules are just as long, if not longer, than the policies. So we're just asking to review them ahead of time to be proactive and try to help those consumers. The other pieces within this is updating form to filing the term. Because the original law was set up to approve policy forms, and now we're asking for not just policy forms, these rules. And working with LSO, they felt the term filing would be more appropriate for those. And that carries through towards the end of the bill. You'll see several strike-throughs of form and replacing filing. And that pretty much concludes the bill, and I stand for any questions.
Okay, let me do a little housekeeping first before we do that. We may get to the 10:30 topic early. And so could you check with the presenters of that and see, and I don't know if Mr. Secretary is coming here or if he's going to be by Zoom. I don't know that, but yeah, so we could figure out. We obviously won't start without him here, but if we could start earlier, that would be helpful for the rest of the day. Back to questions on this bill for Ms. Howard. As Chairman Olson.
Thank you, Mr. Chairman. You talked about the survey of the states. Did you also survey, or do you have an understanding of the notice provision that other states have? How many states have a notice provision? What's its threshold look like? Ours is 30% proposed. Some more information on that.
Ms. Howard.
Mr. Chairman, Mr. Co-Chairman, I want to clarify that are we referencing 30% for the rate notification?
Mr. Co-Chairman?
Yeah,
Okay, yes. So in terms of the 30% for the rate notification, since Wyoming is the only state that does not have a rate filing requirement, I did not, I surveyed the state in collecting other states and collecting the data confirming that we are the only state that has no requirement to file any sort of rate notification or rate itself. So that we are still one of, with this rate notification, we would still be the least regulated in terms of insurance rates in the country. 30% was how we got to 30% was based off of complaints that we've received in the department. 30% seems to be the trigger. Not everybody calls for 15, not everybody calls for 20. Obviously, we have some people who call for 5, but 30% was really the trigger of saying, yep, I am definitely calling my agent, the insurance department, or I'm filing a complaint. It seemed to be the trigger moment. So based off the complaints that we've received at the department, we arranged it or arrived at 30%.
Mr.
Go ahead.
Mr. Chairman. And so we're the only state without a notice provision like this. But what was I mean, I imagine we've probably been in that position for a while now. So what is the genesis of why you're bringing this to us now? Is it the complaints that you received, or what's bringing this forward?
Commissioner Rudin?
Mr. Chairman, Mr. Co-Chairman, one, I mean, we've had this problem in the past where there's a large increase and we're besieged with these calls. And we were trying internally to think, how can we get ahead of this? And so, for example, if we get a notice that a certain company is going to have a 50% increase, we can post that on our website. And so agents and brokers can see, oh, I have this many clients are going to be affected. I need to start working. And so I remember from the conversations in Lander with Senator Case talking about your businesses and how you got noticed and you got hit with all of this. If this were to pass, your broker or agent would have 30 days notice to start looking elsewhere and giving you more options. So we wanted to be proactive and just get ahead of this curve, as opposed to having to field all these calls after the fact. And so that was for our perspective. And we had talked about this as a group. We said, how can we do this? And we came up with this.
Anything? Okay. Anybody else? Any questions from the committee? Any questions at all? Got Senator Barlow on line. Go ahead, Senator.
Thank you, Mr. Chairman. So my query is, while I appreciate that the department wants notice, seems like it would be pretty important for the consumer to have advance notice before they just get their billing, if you will. So was there discussion about, or is there elsewhere in statute where the consumer gets an advanced or a longer lead time on increases, let's say 30% being the mark for the consumer, not for I mean, your office being prepared, I certainly can appreciate that. But what about the consumer? What are we doing to actually give the consumer more time to actually go out and look for other options? Thank you, Mr. Chairman.
Thank you, Senator. Deputy Commissioner.
Mr. Chairman, Senator Barlow, yes, we already have in statute within Chapter 35 our renewal and non-renewal requirements, and insurers are required to notify consumers within that 45-day timeframe of any changes within their renewal. So when the price changes or any type of renewal, when that policy comes up, they have to notify consumers within 45 days.
Okay, Senator Boner, I'm sorry. I apologize.
Thank you, Mr. Chairman. Just trying to understand this because we don't regulate rates. When you receive these complaints, it sounds like there's nothing you can actually do except respond. And so I'm just wondering, kind of, I understand the workload, but I mean, what's the point if it seems like the result, if you don't like your insurance, is to go find a different insurance company. And so I'm just trying to better understand what role your department plays in all this if we're not regulating rates. It seems to me, and even Commissioner, your comment that somehow the insurance agents aren't aware of this rate increase. I need more information on that. It seems like they'd have some idea what's going on within their own company. They wouldn't need the Department of Insurance to tell them, just a little bit more information to help me understand.
And it might be, Senator Boner, independent agents too. I'm not sure how they're tied in, but yield to the commissioner.
Yeah, Mr. Chairman and Senator Bonner, yeah, that is correct. There's a lot of agents out there that are independent. They write across companies and they don't know this. I've gone out and talked with agents throughout the state, and they've all said that we would love to know this. I would love to get a 30-day head start on helping my clients do this. As far as, other notification, I'm just trying to do what I can do ultimately to help consumers, and at the same time, not trying to, increase I don't want rate authority. I don't have any actuaries. I don't want to take that on. We're not asking for that. I'm just trying to help consumers here as best we can, and obviously prepare our staff for when the calls come.
Senator. Anybody else? Any other questions? Any other questions? Any other questions online? Okay, let's do public comment. How about I detect that this is controversial, and so would you just sit there? Is that all right? And we can do some back and forth. Ms. Wilkinson, we'd love to hear from you. Thank you. And Senator Barlow, you had another question? I'm sorry, I missed it.
Mr. Chairman, actually, the second part of this about the rules is probably the more significant part. The 30-day notice is one thing, but I think the second part about the rules, but I'll defer until after maybe Ms. Wilkinson goes and we have some more committee discussion. Thank you, Mr. Chairman.
Thank you, Senator, and I apologize if I went too fast. Ms. Wilkinson, welcome.
Thank you, Mr. Chairman, members of the committee. Again, Catherine Wilkinson on behalf of American Property Casualty Insurance Association, also on this bill representing, and I need to get my paper for the acronyms, the Rocky Mountain National Association of Mutual Insurance Companies, which is known as NAMIC, and the Rocky Mountain Insurance Association, RMIA. So collectively with those trade associations, we represent the majority of the property insurance that is written in the state of Wyoming. Mr. Chairman, we are here today to stand strongly in opposition to this bill. It would be a drastic change from the way that insurance regulation is done in the state in Wyoming today. I would offer that we have been meeting with the department to try to increase the communication. That seems to be why this bill has been brought, and that we do support companies complying with all of the insurance laws of the state. And so we do not condone those that are not in compliance with the state. However, we do not think that this legislation is appropriate to address that problem. Mr. Chairman, this legislation is a significant departure from the regulatory no-file insurance rating system that has been operated successfully in the Wyoming market. It is a competitive market, and we believe that that maintains a stable business environment. Specifically, Mr. Chairman, on the bill, Section 107 with the filing of rates, we do acknowledge that this language is better than the first draft that we saw at your meeting in Lander at the First Corporations Committee meeting. However, we still just think that with the submittal of the rate changes, consumers should already be receiving notice from their insurance companies, as should agents. We do think that 30% is just kind of a random number. As you know, we've asked the department, it was thrown out there that number was given because that was when they see the increase of phone calls. We have offered more solutions that don't require a law to be put on the books, such as data calls or surveys, or communicating this information with our quarterly meetings, which we have committed to with the department. Mr. Chairman, we also would like to comment on Section 2615-110, the filing and approval of application forms and other documents. There is significant concern from the industry on this section. There are lots of states that do require filings of rules. There are no states, I believe one, actually, Connecticut, requires approval of those rules. There is, let's see, that none of those states require the review and approval. And sorry, I have it in my notes here. Yes, Connecticut is the only one. Connecticut is a very stringent and burdensome regulated state, and they do require that. In addition to this new requirement, rates and rules are usually filed together if the rates are not approved, but the rules are going to be required to be approved. That is an issue. We also have concerns that draft, this language does not contain any provisions that would permit an insurer to keep their guidelines as trade secret and confidential. Let's see, Mr. Chairman, I think that is all I had on that section. The last section, there is also concern on section 111. Just when you use the term filing, should this piece of legislation go forward, we would recommend that you actually provide a definition to filing because the word filing has significant impact within the insurance industry rather than the word form. I would tell you that this, just with the filing of a lot of these forms that is required in this legislation, it will be an obstacle for some of the smaller companies, domestic companies in the state that are struggling with profitability. Just as it would be a change in their system. Is it doable? Yes, but it would be a change in the system that would take time and cost a lot of money. Mr. Chairman, I guess I would just say in closing that we think that the open market has been very good and stable for Wyoming. We do recognize that it is a hard market right now. It is a tough business and everyone's rates are getting higher with all of the wildfire that is going on across the country. I would add that we do have concern that if the department with their staff of 26 cannot handle phone calls, we do wonder at the administrative effect of all of these filings will add to them as well. So we have had that conversation with them. Mr. Chairman, I believe those are all the comments that I have right now, but I'm happy to visit with you further and answer any questions. Thank you.
Thank you, Ms. Wilkinson. Let's start with the committee. Any questions for Ms. Wilkinson? Any questions down here? Senator Scott?
Mr. Chairman, my question is on the rules, the provision on page 4, lines 9 through 18, etc. It seems to me, and my question is, am I right in thinking the insurance companies have to file and get approval for the policy forms, do they not? And if that's the case, and these rules are then being used to modify those policy forms and put in provisions that are not allowed under the state law, why shouldn't the department have to approve the rules? There's something here I don't understand in the difference between a policy form and a rule and the extent to which the rule can modify or add to the policy form.
Thank you, Senator Scott. I sort of going down the same line. So I also have a question in that area about really what is the difference between the form and the potential broader net of the filing. And so, Ms. Wilkinson, can you help us maybe?
Mr. Chairman, I will do my best to explain. I may have to call a friend for specific details. As
Okay.
I understand it, Mr. Chairman, the forms are one thing of where the commission can see them and they approve the form, but they're not approving actual rates. And a lot of the underwriting rules are what, it's if you take the base of like a statute, that's the outline of the authority. And then the rules that anyone might promulgate is the details that fills it in. So with an insurance contract, that is much the same thing. So they're approving the rules that the form of the way it looks and that is okay to go out to consumers and that it complies with law. But the rules take a deeper dive into exactly how they arrive at what rate they arrive at to what premium you're going to end up with.
Yeah, and Senator Scott, I think I'm with you on this. So before you're approving a form, that seems perfunctory. That's a piece of paper. It's very thick. It tells you all your disclosures, blah, blah, blah. But when you say now there'll be approving a filing, which is a broader net, which potentially includes all these rule type things. That's what you're getting at here. And is that the nature of your question, Senator Scott? And Senator Scott's basic question is, why shouldn't you have to file that?
Mr. Chairman,
Go ahead.
Mr. Chairman, as I said, a lot of states file rules. There's only one that approves them. So I think that is where a lot of the heartburn is with these companies, is it's a complete departure from we don't approve the rates in the state. And by having to approve the rules, you're not having to approve the rates, but you're approving the rules that basically are the basis for the rate.
Okay, anybody else welcome to jump in here, and then we're going to hear from the department on this. But would you, Senator Scott?
Mr. Chairman, I'm trying to get at what the nature of the company's objections is. Am I seeing that a number of the rules apply to how you do the underwriting, and that affects your rates? And you're seeing this potential provision as being a backdoor way for rate regulation. And I very much support our lack of rate regulation. But I think what the department is getting at is trying to find that there's some provisions that are coming in these rules that do violate our state laws. And I'm wondering, am I understanding the concern of the companies correctly? And then I will ask then I ask the department when they speak to think about how can we get at what you're interested in the rules without leaving it open for a backdoor for rate regulation.
Ms. Wilkinson is nodding. I'll let her comment on your comment, Senator Scott.
Mr. Chairman, and thank you, Senator Scott. We do agree. And companies are in violation of law. That is not something that we support. But we don't think that you should be punishing those companies that are in compliance with law by changing the entire system of Wyoming for a few bad actors.
So let me venture forth here, and then we're going to go to the department. But you're objecting not to the old way of filing the form and having it approved. You're not really objecting to providing the rules, or the other information. You're objecting that those would be approved by the commissioner. Is that fair, or have I gone too far?
Mr. Chairman, yes and no. I mean, it would be a change in the system to file rules. It would be a lot of extra paperwork. It is doable, yes, but it would be a very big departure from the current system of only filing a form. And those rules are, there's no provisions in here for any confidentiality or trademark. That is how you arrive at the rate, is the basis of those rules. So there is significant concern about needing to file those and the approval of it. Where we had less heartburn is the 30%. I think that can be very easily achieved by other means than putting another law on the books, by a data call or a survey.
Okay, so let me go back just one more time. Your companies are not against providing the information to the department. It's the approval of that piece that gives you heartburn.
Mr. Chairman, yes, and the filing. I mean, the whole thing, the approval is very definitely an issue.
Okay.
Yes, thank you.
Let's take another time out for housekeeping. Mr. Secretary, welcome. Good to see you and your staff. We're slightly ahead of schedule. It may not amount to a hill of beans because it's getting closer to the 10:30 start anyway, but we thought we were going to be ahead of schedule, but we'll see what happens. We're going to take a break after this. And this is our last building insurance area. So with that, I'd like to go to the Department of Insurance and maybe have you guys, Commissioner and Deputy Commissioner, help us with the thinking here.
Okay, Mr. Chairman, I guess I'll address first the reason that the word approval is in the bill. If we look at the rules they file with us and they violate statute, I want to be able to say, that's not approved. You have to take that part that violates the law out and not consider it. That's the only reason we want it there. We want to have the ability to say it violates our state law, get rid of it. With regards to the reference that we have other ways of dealing with this and the reference to data calls. We do have authority to go to a company and say, we are interested in this information. We want to do a data call. We have 1,250 insurers that we deal with. We have one person in our office that does data calls. Theoretically, we could maybe pick and choose one here or there, but we would never get to where we need to go. It's an impossibility with that. And it's certainly easier for them to ask us or for them to give us something proactively where we can say it does or does not, violate the law, or it does or does not meet the, this instance, as opposed to the reverse after the fact, after something's already been a violation of the law, after the consumer has already been harmed and maybe they weren't paid on their claim because the underwriting rules changed the terms of the contract without them knowing it. That's after the fact, after the harm has been imposed. We're trying to get ahead of it.
Okay, thank you, Commissioner. Anybody else want to jump in here? Let's go to Representative Newsom and then we'll do Senator Landon.
Thank you, Mr. Chairman. The other point that was brought up was the confidentiality of these rules and the proprietary nature of them, and how are they protected now from a confidentiality standpoint?
And this is directed to the commission. Yeah. Commissioner?
Mr. Chairman, Representative Newsom, if they're stamped confidential, we'll treat them as confidential. I don't know if there's something on the books right now that says they're confidential, but we would treat it as such if it's stamped as such, it's marked as such.
Senator Landon?
Thank you, Mr. Chairman. So this is a tough one. I think we've earned the right to talk about this as a policy because all of a sudden it's a top tenner. The way of the world right now, every one of us on this panel have already gotten a call on insurance. And that's never happened before, but it's happening now, and it's a big deal. And so in the backdrop is all of that, part of our jobs is to protect our consumers out there. And so I'm struggling to get up to speed with that piece of, we don't mind filing. It feels like if it's the approval that is a concern, and I'm looking at Ms. Wilkinson on this one, if it's the approval that's the concern, would just notification, if a rule is outside our statutes, would that be better? Would that be adequate? Help me a little bit more with the piece of the approval versus the report.
Ms. Wilkinson?
Mr. Chairman, thank you. I think that this goes beyond just the filing of rules. I think it kind of negates the entire competitive marketplace with Wyoming by requiring this filing and approval and sharing of this proprietary information of how you arrive at your rates. Mr. Chairman, I hear you on the marketplace is very hard right now. It is difficult, and I'm sorry to hear all of you have had a bunch of calls on it. But I think by asking this requirement, which is complete change from the way we've been doing business in Wyoming, is not going to make it a better marketplace.
So I definitely get that point, but I'm still looking for maybe I'm stumbling a bit, but if someone has a rule that violates statute, isn't the state of Wyoming have the ability to look at that rule and be able to say this violates statute?
Mr. Chairman, yes, and that, I think they need to use the tools that they already have. Now, in terms of, I do hear what they're saying, if a rule is violating and they're not seeing the rules, but I believe that they have the ability to open up and look and investigate a company if they're receiving complaints that this company is not following the rules. And proceed down different routes than require a filing and approval of all rules for all insurance companies, rather than those that are just in violation.
Yeah, and I'm having a little trouble with the whole approval thing. I'm not sure that that's quite it. You don't, maybe a determination that a rule violates statute, for example, rather than approving the rules. Maybe that's the same thing. I don't know, but that doesn't amount to a hill of beans because you guys don't want to file those anyway. You say that it's violates our competitive status and you don't want to roll that back. How are we doing here? Commissioner, we're just going to have to tough this one out, I guess. You're welcome to respond and we'll get to a vote on this bill.
Mr. Chairman, if it's any solace, if a rule violates statute, we could specify it won't be approved. Limit approval to what is in compliance with state law.
I sort of like that. Senator,
Disapprove what violates state law.
okay, let's hold on, Senator Scott. Hold on, Senator Scott. We're going to do Representative Harrelson, then we'll do Senator Scott.
Thank you, Mr. Chairman. So Director, let me ask this question. So currently, if you have a bad actor, let's say a company coming in that is not in compliance some way, because you said we've got insurance companies that have rules that are not in compliance with state statute. If that currently happens, what is your course of action under current statute?
Ms. Howard.
Mr. Chairman, Representative Harrelson. So right now, since the rules technically don't have to be, there's not a filing requirement for the rules, but there are companies that file them because they file them in other states and they file them. So we object to them and say they're not in compliance with Wyoming law, and companies have been well received in updating those. It hasn't reached the point where we'd have to formally disapprove, and we would have to, I'm not an attorney, but we'd have to check with our staff attorney and AG to see if we would even have technical authority to formally disapprove and allow. There's other provisions under our statute where we could allow that insurer, if they disagreed with our interpretation, to a hearing, but it wouldn't necessarily fall under this 2615 under the policy. And that's part of the reason in our discussion with the trades as well, of why we put it under here is because, and had that approval piece, because as we treat policy filings today, if a policy form comes into our office and it's non-compliant, we object and we approve or disapprove. And there are provisions within this saying we have to approve it within 45 days. If we don't approve it within 45 days, it's deemed approved by the commissioner automatically. That's a speed to market kind of catch-all to help the insurers. But we wanted to have those, put this in here to have approve or disapprove, just so we have that authority. The department, and we've had this discussion with the trades as well, we're open to other language, but if we just put in, we would really probably have to create a new section, and that's probably an LSO question, because if we have a requirement for the rules to be filed, right now, as it stands in statute, we do not have the authority to do anything if they are non-compliant. We would have to, which is why we bulked it in with the policies, because we want to treat them the same. We want to review them in the same and be consistent. Are they compliant with Wyoming law? If they are, we're going to approve them. If they're not, we're going to object. And if it continues on, we'll disapprove that filing, and we want that formal authority. I hope that helps.
Follow up.
Thank you, Mr. Chairman. So you mentioned the businesses that, or the organizations that actually do file with you currently because they do it in other states. What about the ones that don't? What about the ones, like, is there a way that you can access that to check on? Let's say you get a call, your 26 people get a phone call. Hey, you know what? Insurance company Y did fill in the blank, and I don't know if that's legal. What's your recourse at that point?
Ms. Howard.
Mr. Chairman, Representative Harrelson, that's a great question. The problem with the rules is you as consumers, me as a consumer, and us as a regulator, we don't know they exist. So the only way to know and how they apply and what they are, that there's not a catch-all per se. We do get calls, right? We do get complaints saying, well, my insurance company did this and we have to research it, and we would reach out to the insurer and say, but even at that time, we don't know that it's a rule, an underwriting rule being applied. We check the policy and then we ask the insurer, okay, you know, we've reviewed this policy and this provision isn't in the policy. So how are you arriving to this conclusion, or why are you applying this fee, or why are you applying this coverage this way? And the insurer would say, this is based off of a rule. And so we would have to ask for that rule. And that's very reactive. It's not something that we automatically get a complaint and automatically know it's a rule. Also, you don't know what's out there when you don't know, right? So it's kind of fishing for a needle in a haystack a little bit to know what is the rule? Are they compliant? Is it okay or is it not? And what rules are out there? It's a very unknown, and we're trying to increase that transparency piece.
Thank you. Let's go to Senator Scott.
Mr. Chairman, what I'm going to suggest is that I think that there's a way that the commissioner and the trade association could probably come to an agreement on dealing with these rules that got away from the business of having to approve all the rules, give him a specific authority to disapprove parts of the rules that violate Wyoming law, maybe give him specific authority to tell them that they have to file any rule that increases, that puts a fee on that's not included in the premium, because that seems to be where some of the problem is. And that's a way they're evading our insurance tax, premium tax. So that's an issue. I think if the two of them were to get together between now and the next meeting, they might well be able to work out a compromise that would give the department what it really does need, because it does look like these rules are being abused in some cases. But maybe one that we can avoid a mass filing and avoid the mass requirement for approval of the rules, which I do think could lead to the unintended consequence of losing our status of saving money by not regulating things that we aren't going to, and changing that whole scheme. Mr. Chairman, while the floor, I'd also point out to LSO that on page 2, line 21, there's a violation of the drafting standards that they could take care of very nicely.
You mean that damn such?
That's exactly what I mean. I didn't add the description.
We'll deal with it appropriately, I promise, Senator Scott. Any comment from either side on Senator Scott's, I don't think they want to do this, Senator Scott, but anyway, let's go to Representative Ottman and then we'll discuss it.
Thank you, Mr. Chairman. I was just wondering, to put this underneath your office, what would that do to the size and scope of your office? Any changes at all?
Commissioner?
Mr. Chairman, Representative Ottman, if this bill were to go forward, there'll be no fiscal note from our office.
And just to be clear, even though they're funded by the premium tax, there still would be a fiscal impact that the Appropriations Committee and the legislature would be informed of. And they're saying, no, that won't happen. Anybody else? Okay. Anybody else want to address the committee? We'll let you guys maybe take a break and then we'll hear from Mr. Allred. Is there any online? Okay. Mr. Allred, welcome.
Thank you, Mr. Chairman. Just a couple comments on here. I know the thing about notification on rate increases. it's a little personal to me. This last September, all of a sudden I got, with no notice from my insurance company, I got a notice from my bank that my escrow account was severely in arrears. And I called up and found out, well, the insurance company had changed my property insurance from $6,000 a year to $12,000 a year. 100% increase. And when I called them up, I said, I've never had a claim on you, anything. Why did you? They said, well, that's just what our rate went to. So I get no notification or whatever. And that's far and exceed of the 30%. I don't know if 30% is the right number or what, but when they do something like that, so then I immediately found a different insurance company and actually dropped it to $5,400. But the fact that they did that, and I mean, if my bank hadn't called me up, I would have been in big trouble there. So I agree with this. And I think that for this type of reasoning, a notification to the state that they're going to be making a big jump, I think that's appropriate.
Thank you, Mr. Allred. Let's see. Any questions for Mr. Allred? Thank you very much, Mr. Former Secretary.
Thanks.
You bet. Anybody else wish to address the committee? Anybody else in the audience? Anybody online? Committee, you've heard the testimony. What is your pleasure? Got a motion by Ottman. Is there a second? Is there a second? Got a second by Landon. Discussion on the bill. We can wrap it up today with a roll call, or we could try to send them back to the table. We've got one more meeting. Senator Landon.
Mr. Chairman, thank you. I think everyone can tell I'm struggling with this. I've never been one for regulation, but I'm just getting the feeling that maybe we haven't completely worked this out. I thought Senator Scott did a good job of outlining a couple of options that might be considered, but the committee can do that too. If we move this bill forward, it's got a long ways to go as we work it through a session. We can work with our property and casualty folks and try to get some language change. I'm kind of like Mr. Allred. I had the same thing happen to me this year. Same thing. I got a call from the bank, a notice from the bank in Casper that, hey, your escrow's underwater. So that's happening. And I've run into so many constituents that are having these insurance conversations. But so I'm inclined to support the bill going forward, knowing that we may have some work to do on it. This is kind of a sunshine thing, and it's an issue that's going to carry that we're all going to face going forward, Mr. Chairman. I really believe that this insurance piece is going to be big. So thank you.
Well, thank you, Senator, and thank you for that. I do have a concern that the bill would die with a roll call vote. And absent a reconsideration, we wouldn't be able to bring it back. And so I would maybe think to the committee that if you feel that the bill could be salvaged with pushing people more towards the table, then that would be the suggestion along the line, Senator Scott, that we lay this bill back till next meeting, encourage the folks to get together. And Senator Scott has his hand up, so I'm going to call on him, and then I'll come to you, Representative. Senator Scott.
Mr. Chairman, frankly, I couldn't hear what Representative Ottman's motion was. Is it to carry it forward to the next meeting, or is it to introduce the bill?
It's generic. We're actually discussing that at this time. So basically, I think it works. We're treating it as if it's to sponsor the bill. And I have signaled that it might be appropriate, if we want to go down the route that you suggested, Senator Scott, that we table it to the next meeting with some direction. And so
Mr.
and a
Chairman?
tabling motion would have precedence. Senator Scott.
Mr. Chairman, I would then move that we do carry it forward to the next meeting because I think that we can fix the problems.
What do folks think about that? It's not, it wasn't exactly a formal motion to table, so I'm going to treat it as informal and we can have discussion. Senator Boner.
Thank you, Mr. Chairman. Yeah, I appreciate it. I think that would be wise to move it forward. I'll be a no on the bill as is. I heard the concerns. I don't see how the bill addresses those concerns when it's notification and to the insurance department, not necessarily the consumers. And just think that and we need to find some sort of middle ground here, especially with the approval of the rules that the industry strongly objects to. So no, for now, open to the concept, want to understand the impact this has on our constituents, but I don't think this bill gets us there right now.
Okay. I'm seeing a lot of head nodding on that one, I think. So Representative Haroldson.
Thank you, Mr. Chairman. Just real quick question. And maybe we've slept quite a bit since then, but did you guys already take this to the table together? Was that something, because I remember we had that conversation in April. Was that correct? So would this be like 2.0?
Maybe.
Okay, I just was checking.
Well, frankly, yes. I mean, we can go ahead and push it through as a vote and then we could do a straw poll, but I think it might fail today. So we just have to see, but we do have a priority motion on the table that's just move it to the next meeting with some folks to maybe encourage them to get together and see what happens. That's kind of a priority motion. So Representative Ottman, we're going to vote on that after your comment.
Thank you, Mr. Chairman. My comment primarily to industry and to the commission. Primarily, we need to, in this time, we need to do something for consumers. To have people not notified and to find it out from their banks does not give them time to look over industry and look for a better way. To have your insurance go up $200 a month and not be notified about it is unconscionable. And so that is my reason for pushing that. And I think you can understand why that would be a grave concern.
Thank you, Representative Ottman. I think I might be wrong, but I think in those cases where people were not notified and they found out due to deduction that violates, that is an existing violation and for both of you. But sometimes you got notice in other ways and you didn't see it, you know. But anyway, let's get to the Senator Scott's basic deal is to carry this over and encourage the parties to work together. We'll take it up again in October. All those in favor signify by saying aye.
Aye.
Any opposed? We have a no out of Newsom. Didn't mean to identify as a voice vote. Okay, let's take a break for 35 minutes. Yeah, we're going to be late now when I thought we were going to be early, but we're going
Mr.
to.
Chairman,
Yeah.
I just have one bit of news. We missed this yesterday. You know, yesterday was the birthday of our esteemed colleague, Representative Wiley. So I just want to make sure we're wishing him a happy birthday.
Mr. Chairman,
Josh.
we do have someone online to do public comment on insurance in general.
Okay, let's hear it. We'll hear it and then we'll take a break. Ms. Smith? You know, she may have heard that we were taking a break and
Oh, nope, I'm here.
Is she there?
Huh,
okay, all right.
hold on. Let me get going.
We don't see you yet.
Yep, good. All right.
There you
Mr.
go.
Chairman, thank you. Members of the
Welcome.
committee. Thank you. I'm Marion Smith with the National Insurance Crime Bureau. Spoke to you all the last meeting in Lander regarding fraud awareness and fraud reporting within the state of Wyoming. Wyoming remains the only state that doesn't have it on the books. Really appreciate the department for including us as well as industry in their last meeting this past spring. And together we all agreed that fraud reporting should probably be a standalone bill And during that interim, took a look at other states as far as what to model. There was discussion that maybe not modeling after Incoil would be so good, as Wyoming definitely is a bit different. So what I'm recommending and asking very respectfully of the committee to do is to request LSO draft model language regarding insurance fraud reporting, to model that of Montana. And basic reasons for that: Montana does not have a fraud reporting unit within the division, and neither would Wyoming. And Montana's law is very straightforward, 3 points really within it, and that's the statutory requirement to report suspected fraud insurance, and a statute regarding that, the duty to cooperate. So if there is an investigation going on, insurers have a duty to cooperate with the commissioner and the Department of Insurance and records pertaining to any kind of investigation. And then the third part is one that was brought up as a concern in Lander, and that is statutes and language regarding immunity that would provide immunity from liability for cooperating with an investigation and providing requested information. So our ask is pretty simple, that we take a look maybe at Montana's law for your October meeting, and I'd be happy to answer any questions.
Questions from the committee? Commissioner, can I prevail on you to come up? This one's catching me a little bit off guard, and asking for, we don't have that statute in front of us. I don't know what Montana does. I have no idea. So can you help me think about this?
Mr. Chairman, yeah, we had met with the trades and we talked about possible model laws. You might recall when we met in Lander, we had it in our bill.
Right.
And they wanted more than that. And I had some reservations. And so we just said, well, you should bring it on your own. Montana does have a fraud reporting mandate bill. They have 4 fraud investigators for this sort of thing. I double checked their manning before we came up here today in case we were asked. They do have 4 people in their office. We have none. But be that as it may, that's fine. That's just the facts as they are. So
Okay. Ms. Wilkinson, the trades, any opinion on this? We're getting there, you guys. Hold on. So at the end of this discussion, we'd entertain a motion to pursue a bill draft along this path, I guess. Ms. Wilkinson.
Mr. Chairman, members of the committee, Catherine Wilkinson on behalf of American Property Casualty Insurance Association. Ms. Smith did send us the bill. The initial, I think we are neutral, but we're still reviewing it.
Okay. Thank you for that. So committee, I haven't seen this bill, but and maybe it was sent to me, but I don't really know what we're getting into, but are we willing to have a bill drafted along those lines? And yes, sir, you'd like to address this? Okay. What's your pleasure, committee? No harm, no foul.
Mr.
Representative
Chairman,
Harrelson.
I guess, I mean, we're obviously on our second to last meeting. We've got one more meeting. We have already packed some into that meeting. And I question the fact of is it intelligent to kind of take a swat at something that, I mean, it could be simple, but it never is. And is it something we want to do and then push something into sessions that maybe isn't exactly ready for sessions? I don't know. I'm just, not that I'm not opposed to it. I'm asking the question if that's a good policy decision to try do that.
Well, Representative, we're the best committee in the legislature.
Absolutely.
And the hardest working, and we can tell if something's not good for the people of Wyoming, so we could decide that it isn't at that time. And so kind of doesn't hurt to look at a bill, but also, are you aware of this? Do you have any idea what the workload would be?
Mr. Chairman, I believe an example was sent out to the committee
Okay, I
on
apologize.
Monday. And it doesn't look like it would be a huge lift, but up to the direction of the committee, of course.
Okay, committee. So looks like it's doable. Do we want to do it? Have a draft only. Senator Landon.
Mr. Chairman, I'm looking at what was sent to us. I'm intrigued by it, given the fact that Wyoming is the only state that doesn't have any provisions in law in this regard. And so that alone might be worth our discussion in the third meeting. Three provisions modeled after the state to the north of us, which doesn't give me that much heartburn. So I would make the motion that we go to a bill draft and get a look at it in October.
Fair enough. Is there a second?
Second.
Got a second by the co-chairman. All those in favor signify by saying aye.
Aye.
Opposed, no. Okay, we'll do that. There you go. We'll see you.
Thank you.
Let's take 10 minutes and come back at 10:40.
Flip that order so that we maintain the $10 million. That's gonna work. Is there I'll take notice when you're on the floor. Make it like, hey, do Tuesdays or hey, do Tuesday.
Like the shoes.
Hey, they're comfy.
I'm sure they are.
Like walking on a cloud.
All right, let's call the meeting back to order. We're at the point of our agenda, guess I'm on the wrong page, but this is the report from the business fraud working group. And we have our Secretary of State here is with his staff. Welcome. Do we have other members of the fraud working group online? I have heard from Tara Berg and she's not able to join us. But Mr. Weaver or Mr. Meyer?
Pope.
And Mr. Pope, I don't want to forget Mr. Pope. And then Mr. Co-Chairman, I sort of looked to you a little bit. You chaired this working group and appreciate the good work that you did. Do you want to give any kind of an overview before we dive into these bills?
Sure, Mr. Chairman, while we're figuring out who's on, did we figure out who's online?
Representative Knapp, we left. Well, let's just leave him open until the end of the day. Whatever you choose, he's your member.
Representative Knapp?
He's mineraling.
We'll just keep him open and when we get him, I guess.
Okay. I do see Mr. Weaver. Let me know when Mr. Meyer's around and Mr. Pope, if he's joining us. I did hear from Tara Berg and she had a family emergency. I hope everything's okay, but she will not be able to join us today. So to you, Mr. Co-Chair, for kind of introductory.
Yes, just a brief introduction. Our working group met by Zoom. The assessors were represented by Ms. Berg. The Secretary of State was present. And then we had some industry folks representing accounting, legal, and I guess banking and trust world, sorry. And probably the main topic of discussion centered around registered agents. As this committee will recall, at our last meeting, Ms. Berg brought a significant amount of information forward to us about registered agents in certain instances where fraud may be an issue, or at least a level below that where people are using addresses that certainly aren't theirs or their registered agents. So we dealt pretty significantly with the registered agent problem. The committee produced from that 3 bills, which we will hear about, that's providing false information to registered agents. So then, foreign adversary, I guess, is a different problem. And then registered agents, compulsion of production of records. So we'll dive deeper into that. And then I forgot to mention the foreign adversary government ownership of business entities. This was a problem that we discussed as well. It continues to be a major concern in the state of Wyoming that our adversaries may be acquiring property in the state of Wyoming and maybe entering or creating businesses in the state of Wyoming and then acquiring real property or other nexus to the state of Wyoming. So we've got a bill to try to further address that issue as well, and we'll talk more about that. And I thought overall the working group did a really good job. I wouldn't say that we're all 100% on board with everything, which you'll probably hear some of that testimony today, but I think it was productive and a great conversation that the industry had with us. And I think we'll continue that out to the full committee and decide what to do from there. Thank you, Mr. Co-Chairman.
Thank you, sir. Thank you very much, Mr. Co-Chairman. Mr. Secretary, welcome. Did you have any introductory remarks?
Well, I think, Mr. Chairman, if I could make a couple. I mean, one, just want to introduce our team here for the record. I'm Chuck Gray, the Wyoming Secretary of State. To my right is Colin Crossman, the Director of our Business Division. And to my left is Joe Rubino, our general counsel, and also our policy director. I just want to start out and say that we take fraud extremely serious in this administration. And I do think there has been a change in not only tone, but in action compared to some of my predecessors. One of the first things we did when we took office is to ramp up this procedure that was in state law that really was not used very often, if at all, to dissolve entities where a fraudulently filed document was filed with our office. And we've created a procedure to execute that statute, and we've executed it in many instances, including with Assessor Berg with some attestations that she's brought to our office. So I think our administration has been very clear that we take this very seriously. I think we've come a long way from some of the statements previously that had been made on Panama Papers and things like that about this really not being an issue. Our administration views this as a real issue. And that's why we brought 3 of these bill drafts to the working group. And we really appreciate 3 of those bill drafts being taken up. There are a couple others we wanted to make some comments on as well that were also proposed in the discussion, but really appreciate being in the working group and appreciate our 3 concepts being taken up and us having this dialogue with you on this very important issue.
Thank you. And we welcome you to the Corporations Committee, along with the other members of the working group. I think we should just, I see that we're joined by Mr. Meyer and we've got Mr. Weaver. Good to have you both on board. I think we'll just proceed by jumping ahead and letting staff present the bills. You might as well present from right there if that's acceptable to you. We could make some room, but that works for me if it's okay with you guys.
Sure, Mr. Chairman.
Okay, Ms. Adams, go ahead.
So the first bill is 25 LSO 114, Working Draft 0.4, third-party filers. And so this is an act relating to the registered offices and agents. It generally requires third-party filers to register with the Secretary of State. It authorizes fees. It specifies a penalty, and it provides a definition and then also allows rulemaking. Turning to page 2, there's a definition of third-party filer in subsection A. So as used in this section, third-party filer means a natural person who receives compensation to file documents with the Secretary of State on behalf of one or more business entities, and who is not a direct employee, shareholder, director, member, or otherwise under the direct management or supervision of the business entity on whose behalf those documents are filed. A third-party filer may include an employee of a commercial agent or another business entity. Subsection B then provides that a third-party filer is required to register with the Secretary of State after filing 10 documents with the Secretary of State in 1 calendar year. If a third-party filer files 10 documents with the Secretary of State in 1 calendar year, then no further filings shall be accepted unless that third-party filer is registered as required under this section. The Secretary of State would be authorized to reject any document that's filed in violation of this subsection up to 90 days after discovery of the violation. Moving on to the staff comment on page 3, the committee may wish to consider whether to specify a time limit for when a violation can be discovered. So currently it could be rejected anytime within 90 days after the discovery. Under subsection C, this contains the application requirements. So a third-party filer is required to obtain a registration by filing an application with the Secretary of State. The application needs to be notarized, executed, and sworn under penalty of perjury, and it has to contain the following information. So that includes the third-party filer's legal name, their home address, phone number, and email address. If applicable, their business address, phone number, and email address, and a copy of their valid state-issued driver's license or identification card. Turning to page 4, subsection D authorizes a fee. So every applicant is required to pay a filing fee as set by rule adopted pursuant to this chapter. The fee is designed to recover the cost of administering the provisions of the section relating to third-party filers and shall not exceed $50. And if an application is withdrawn or denied, the Secretary of State would retain the entire fee. Under subsection E, A registered third-party filer is required to notify the Secretary of State of any changes to the information that's included in their application under subsection C as required by rule. The staff comment just notes that the fee provision is modeled after a current provision regarding commercial registered agents. Under subsection F, there would be a penalty authorized. So the Secretary of State may impose a civil penalty not to exceed $500 for each violation if a third-party filer is required to register and they either file or attempt to file a document without doing so. The penalty that's specified in subsection F is modeled after current statute as well. Subsection D requires the Secretary of State to hold third-party filer registration records confidential. The Secretary of State could only release those registration records pursuant to a court-ordered subpoena or pursuant to a bona fide law enforcement agency to use in a criminal investigation. Again, that language is modeled after current statute. And then turning to the final page, the Secretary of State would be required to promulgate all rules and forms necessary to implement the act. And then there would be a split effective date. The substantive provisions would go into effect on July 1st, 2025. There is a staff comment just noting that the committee may wish to consider whether to include a delayed effective date because they're required to register if it's in a calendar year. So there would be sort of a question about how to calculate those 10 filings and when that would start. And maybe you would want to start it in January. And with that, I would stand for any questions.
Thank you, Ms. Adams. Questions for Ms. Adams? Questions from the committee? Senator Boner?
Thank you, Mr. Chairman. Just to make sure I understand, on that penalty in subsection F, for each violation, would that be each filing? So every individual filing above 10 that they don't register would be subject to a separate fine. Is that correct?
Ms. Adams?
Chairman Case, Senator Boner, that is correct. It's set up so that each time they either filed a document or attempted to do so, there would be a separate penalty.
Okay, thank you very much. Just before we get started, Mr. Co-Chairman, I never talked about this with you, but by way of housekeeping, these bills are all brand new bills for the committee and really for the public. So I would assume we wouldn't have final votes on them today, but we'd carry them over to our next meeting. But I defer to you, sir.
I think that's fine.
Okay, so that kind of is our plan because that way it'll be out there and provide more notice to the public and because it's, you know, the subcommittee didn't have public participation. So I think that would be appropriate. Mr. Secretary, for the first bill.
Thank you. Thank you, Mr. Chairman. Oh, did the senator?
Senator Scott.
Yes, Mr. Chairman, question on the drafting. Where you have a person, and I'm thinking probably of attorneys, where doing corporate filings, writing articles of incorporation, that sort of thing might be construed as part of their normal professional activity. Are they required to register under this bill or are they not required to register separately?
Ms. Adams, is that a question for you? I'm not sure.
Chairman Case, Senator Scott, I believe they would be required to register as long as they're not a direct employee, shareholder, director, member, or otherwise under the direct management or supervision of the business entity on whose behalf they're filing.
Senator Scott, Ms. Adams' answer is yes, they would. As of this point. So we're going to go to the Mr. Secretary and then we'll take up the other members of the working group and then go to public comment. Mr. Secretary.
Thank you, Mr. Chairman. As the committee remembers from our discussion in April in Lander and then also the working group, the intent of this concept that we presented to the working group and really appreciate being taken up was to ensure that serial third-party filers are verified as real people. There's been real questions about that, and that's what this bill is attempting to address. This bill draft would require third-party filers who receive compensation from business entities to file documents on their behalf and who file 10 or more documents with our office to register with our office and provide both a notarized sworn application under penalty of perjury attesting that the third-party filer is a natural person, as well as provide additional documentation, including the third-party filer's home address, phone number, email address, and driver's license. I support this bill. There are some issues with, in terms of implementation that we wanted to lay out to the legislature here. So I'm going to turn it over to Mr. Crossman to talk a little bit about implementation of this bill, and then it'll come back over to me. Thank you.
Mr. Crossland.
Thank you, Mr. Chairman. So implementation of this bill will require the generation of a new module inside of our system that mirrors to some extent the existing commercial registered agent system, but does have some differences. So it's not just a one-to-one copy paste. But we anticipate the cost of generating that to be between 82,800 and 103,500. And it will take some time for that to occur. After, if this is passed, then obviously we have to have time to build that out, as well as time to do the rules. So that definitely needs to be kept in mind. But what that will do is allow people who are filing. Let me step back and tell you how it works right now. If you are filing online and you pick a commercial registered agent, there's a list and you can pick it. Or you can enter one if you're entering yourself and you're not in that list. If you pick one, it blocks out those fields and prevents you from editing them, but it puts all of the information for that commercial registered agent in there. We would anticipate something like that occurring as well for the individual who is filing the document. So we would have a separate database that it includes everyone who is registered with us, who has filed documents, and they would pick themselves from that list, and it would lock that information down. And so that would ensure that, for instance, you don't have, I'll use my name as an example, Colin Crossman in one case and Colin R. Crossman in another case and Colin Robert Crossman in a third case, entering with 3 different entries, making it more difficult for my staff to make sure that each one is tracked. So that's the technical side that has to be built out and done so that all of that can be tracked properly, because it will be incumbent on our office to some extent to make sure that we're catching people who, after they filed it, to tell them and warn them that, oh, hey, you've hit the benchmark. You need to register with us now. And if you don't, these entities will be at risk of having these filings voided when we discover them. On this, so the second side of this is to give you an understanding of what this workload will create. Online is one concern. Also, we'll be tracking these on paper. So as these documents are coming through, all the filing information will be collected and entered into the system. So not only will there be an online component to this new module, but there's a back-end component as well. So you have a tracking component, an online entry for the public, and a back-end entry for the staff. And all of that has to be built out and designed so that we can track these. We can make sure that people aren't accidentally filing things, because we definitely don't want somebody to accidentally have their filings be voided, but also that we can catch people if they are trying to get around it. So I can answer questions on that or move on.
Any questions at this point?
Mr. Co-Chairman.
Go ahead, Mr. Co-Chair.
Thank you. Mr. Crossman, so just want to make sure that I understand that it is an ask for the approximately $100,000, or is that going to come out of your budget for the build out of the module, or do we need to include an appropriation in this bill? Maybe that's better for the
Mr.
secretary. It looks like.
Yeah, Mr. Chairman, our plan was that there would be an appropriation of 80 to 100,000 in the bill. And then, and we would appreciate if there was a little cushion there. I mean, we're very responsible in terms of our vendor in the build out. We're not going to, I want to make a note on the staff burden, but we're not going to make a request in tying any positions, but want to tie it into our discussion with appropriations in all of the things that our office is facing, including the increased number of filings. But our hope was that we would have that appropriation in the bill itself.
Okay. Anybody else for Mr. Crossman? Representative Newsom.
So on page 4 on line 6, the filing fee, or the fee to these folks that are doing these multiple filings, is only $50. And I'm wondering if that is enough, given the expense of the software, if we're looking at recovering costs for that. The other challenge that we had just in this committee yesterday was we had one of the fees that hadn't been increased since 1988. In my other committee, we had a fee that hadn't been increased since 1980. And so I'm wondering if we want to build into that maybe up to $200, not that that would go to $200 right away, but that the Secretary of State's office would have the ability in the future to move that amount up as we see inflation and as costs increase.
Thank you, Representative. Mr. Secretary.
Well, Mr. Chairman, the Secretary of State's office has historically been funded out of the general fund, something that we would be happy to engage with the legislature on moving off of. And in fact, we've requested, previous administrations and my administration has requested us looking at. And, you know, we're one of the few revenue centers of the state other than the Department of Revenue. And we bring in $120 million every 2 years. And we do basically 75% of the work that Delaware has as being number 2 in the nation with 10% of the people. Delaware has over 110 people in their business division, and we have 75% of the work, and we have 11. And so we're very proud of being efficient. We would certainly engage with using our business filings itself in business filing fees itself to pay for this. I think where there would be a little bit of a bifurcation, and we got into this discussion on expedited filings, is using this specific fee to pay for it. Well, how long would it take for us to build up the 100,000? We could try to engage in that calculation, but obviously it would be speculative because the bill is not in effect. So I think utilizing our business fees, I mean, that would be paid for in a day, but I mean, utilizing the specific fee to pay for it, how long until we'd be able to utilize that account, and with the statutory deadline to be able to meet that, that's where I think the challenge would be, and where there might be a little bit of a difference in drafting that.
Representative Newsom,
So,
did that get at your?
No, not
cap?
really. So what I'm not looking for cost recovery of the software at this point. I think an appropriation is reasonable, but in TRW, we're looking at an increase in snowmobile registration fees that hadn't been changed since 1980. And so as a legislature, we are notoriously bad at looking at increasing fees over time. So what I'm trying to get to is if we would make this shall not exceed number $100 or $200, where if you would start at $50 as costs increase, as things increase, you would have the ability to increase that fee over time, because we as the legislature are going to leave it there until 2087 if we don't put the ability for the Secretary of State's office to increase that. We do that with Game and Fish. We do it with several other agencies that allows them to do what the cost is today, but then to allowing them in that up to number to as time goes on to increase those fees on their own without having to come back to the legislature and ask for that fee increase.
Mr. Secretary, back to you.
Okay, well, Mr. Chairman, on this specific one, and I want to be clear, I'm not talking about any of our other fees, but just the new one that would be administered in 25 LSO 114. I mean, certainly getting that right number and keeping in mind subsection D and the intent of recovering the cost of the implementation, which there is a cost to doing that. We'd certainly be happy to engage with the legislature in thinking of an estimate of how many are going to file and whether 50 is right. I mean, obviously the speculative nature of that, of giving that discretion in the future, that's a little bit of a policy call. If in the future you gave that ability to increase, but yeah, I see what you're saying.
Thank you. We'll continue. We might come back to that. Representative Wiley.
Mr. Chairman, thank you. Mr. Secretary, I'm going through here and I'm seeing where you have, for $500 for each violation of a third-party filer. Do you have the authority, or is there a mechanism that once you identify a bad actor, can you purge them from the system and not allow them to participate or partake in the service anymore?
Mr. Secretary. Mr. Crossman.
Thank you, Mr. Chairman. There's a couple of, from a technical side, that can be tricky. But we do have an existing legal mechanism where if an individual is abusing our system, and it's not just the business division, this is for any division inside the Secretary of State, where we can effectively ban someone from filing with our office for 5 years. That's a statute that's already on the books. That by having a fee for this, and a fine effectively, we don't have to jump to, oh, you filed one document with us, you can't file for 5 years. It gives us a little bit more flexibility in that, as well as the banning for 5 years. If it's a fake person, then that doesn't really do anything. If we have a penalty and there is an entity that somehow that fake person was representing, well, then at least we have a potential to go after that money through that entity. Whether or not that recovery is possible in every case, of course not, but it gives us a little bit more tools to deal with it. So yes, to answer your question straight, we do have the ability to ban people right now. That's pre-existing in, I think it's 91308.
Mr. Co-Chairman.
Thank you, Mr. Co-Chairman. I'm jumping back to Representative Newsom's discussion of the fee. I think it's important to point out that it's $50 mostly because that mirrors the commercial registered agent fee, which is $50. So I think just for the committee's edification, that's the reason why it's landed on $50 is if you're a registered agent and this is where the 10 or more comes from as well. If you register 10 or more companies, you have to register as a commercial registered agent and pay the Secretary of State $50. So now we're saying if you're not a commercial registered agent, but you're a third party filer and you file 10 filings, then you still have to register and pay $50. That's where it comes from an existing statute. Whether that $50 is appropriate or not, I guess I'd defer to the Secretary of State's office on whether it is or isn't, but we would probably, if we were going to adjust it up, we would probably want to also adjust the commercial registered agent. Otherwise it would be a little wonky, I think.
Okay,
Mr.
let's try to
Chairman.
keep going. Representative Newsom.
Thank you for that information and thank you, Mr. Chairman. I guess the question becomes, what is the cost and how long has the commercial fee been $50? Has it been since 2000? Has it been, do we know that?
I don't know. I don't recall changing it since we put in the commercial registration legislation under Maxfield. So I don't recall. Mr. Meyer worked on that. He might recall. So we'll get to that when we get there. I just might say overall, I think that the legislature is more tightly connected to the fees of the Secretary of State's office in general than perhaps we are with other agencies. I mean, it seems like there's more look at it, especially the business tax for sure. But
So,
Senator Landon.
Mr. Chairman, just a question, I guess, for you as our chairman. Would a bill like this need a fiscal note? If we know that module is going to cost us, 6 figures, I guess that's the question moving forward, and we don't have to resolve that today, but.
Yeah, when it gets to the legislature, it's going to have a fiscal. That's our rules.
Yeah.
And so we'll have that information. Hopefully we know more even by the next meeting, I suspect. And to put it in appropriation, I think that's good policy if we can hone in on that, and that would be a good plan forward. Let's keep moving. Any other questions for the Secretary? How about if we, Ms. Secretary, anything else? Then I thought we'd go to the rest of the members of the working group.
Thank you, Mr. Chairman. I think we're good.
Okay.
Do you want to talk about the date? Yeah, I think he wants to weigh into the date a little bit. Could we do that on the
Absolutely.
date?
Yeah, go ahead, Mr. Rubino, welcome.
Mr. Chairman, thank you. Just briefly, and I saw Senator Landon was jotting down notes during the staff memo on page 6, or the staff comment on page 6, line 18. committee may wish to consider whether to include a delayed effective date for section 1 of this act, not only for, as Mr. Crossman noted, the building out, but just ease of calculation for the calendar year for filing, especially for the filers themselves. So.
Okay. Thank you very much. We'll take that up. Let's go to the members of the working group and see if what input they would have, and then we'll go to general public. Mr. Meyer, Mr. Weaver, either one of you want to weigh in? We can go alphabetical if you want. Mr. Meyer?
Thank you, Mr. Chairman, members of the committee, Scott Meyer on behalf of Scott Meyer. Just as kind of a background, a little bit on there, we did look at back in 2008 through 2010, we looked at the registered agent statutes. We looked at the corporate statutes, and we also looked at the limited liability statutes. In 2008, we did establish the commercial registered agent provision that said if anybody has more than 10 should register, and that fee was set at $50. So it's been there. I guess my thoughts on this particular bill is honestly is that a commercial registered agent probably is a third-party filer. And so if you look at the firms that are out there, the law firms or accounting firms or what have you that have the ability to form these companies, that they probably are serving as those entities registered agent as well. So when I look at the bill, what you're actually saying, what the bill is actually doing is telling us that, well, you have to file as a commercial registered agent, but you also have to file as a frequent filer. And so we're doubling the cost of these, of the ability of our law firms and accounting firms and what have you to do the legitimate business that they are doing. I would say that most of the time, I mean, what that appears to me, it looks like, is that is not business friendly. And so now we're just adding another layer of cost on there. I'm also have some concern with the bill in that a third-party filer must or may include an employee of an entity. I'm not sure what happens when you have different employees. I guess each one of them has to we have to pay for each of those employees the $50. And then I'm not sure what happens. And of course, then you have to provide the driver's license or ID and everything. And I'm not sure how many employees really want to do that. But then I'm not sure what happens when that employee leaves the employment of their employer there and go someplace else. Does that mean that they have to go then refile as a frequent filer? You know, with the commercial registered agent, you can change addresses at a cost, but you have to do that. So I guess my gut reaction is I'm not sure how this really addresses any fraud. It does seem to put one more additional registration requirement on people that form companies for clients and also serve as a registered agent. And it's one more filing duty that the Secretary of State has to take on. So, like I said, to me, it seems like this is business unfriendly. Stand for any questions, Mr. Chairman.
Thank you, Mr. Meyer. Are there questions for Mr. Meyer from the committee? Any questions? I do see Senator Scott online. Let me see if anybody on the front table first. We'll go to you, Senator Scott.
Question for Mr. Meyer. If we were to say that somebody who is a registered agent has filed as a professional registered agent, doesn't have to can be a third-party filer without having to re-register. Somebody who is admitted to the bar in the state or who is a certified public accountant doesn't have to, because we know who those people are and how to get to them. Would that would reduce the cost of the bill and reduce your objection to saying we got to have these extra filings? Would that do any harm in terms of achieving the purpose of the bill?
Let's go to Mr. Meyer first, and then we'll go to the Secretary. Mr. Meyer.
Mr. Chairman, Senator Scott, I I would agree that that would reduce that cost, and that might make things more simple. I just not sure. I think, knowing that somebody files, whether it's a law firm or an accounting firm or whatever that seems to file a lot of these, or even if it's just somebody, Joe Blow, that's out there that's working on this stuff, that has figured out a niche and wants to do that. I'm not sure knowing that somebody files 10 or more entities is going to be much of a fraud deterrent. And I guess I just don't see that correlation. I'm certainly willing to be educated and have my mind changed, but I'm not sure what having a frequent filer provision in the statute does to actually address a question of fraud.
Thank you, Mr. Meyer. Let's go to the secretary and then, Mr. Weaver, I saw you nodding your head when Senator Scott was talking. So if it can hold till you get to your comments, that would be okay, or we'd give you some time too. But Mr. Secretary.
Well, thank you, Mr. Chairman, for the opportunity to engage on a couple of those comments. And yeah, I appreciate Mr. Meyer. We don't agree with everything on this, but there is a tension here, and I fully acknowledge that. That there is a tension on these questions, and we certainly want to engage with him and with the people of Wyoming and the committee on the tension between transparency and security and sort of having a climate that we've had in the past that has got us to being the #2 filing location in the nation. Responding to a couple of those comments, though, the real intent of this bill is to ensure the third-party filers are verified as real people. And that's really what we're trying to get at in terms of stopping the fraud. And the second thing I wanted to say was I think there were 2 points Mr. Meyer made in relation to who would need to file. One was that a commercial registered agent employee would need to file as a third-party filer. That I agree with in the definition on page 2 of a third-party filer. But I believe his second point was that an employee of the business itself would need to register. And if that is what he was saying, I do not agree with that, because clearly in the definition, it says that a third-party filer means a natural person who receives compensation to file documents with the Secretary of State on behalf of one or more business entities and who is not a direct employee, ... So I think the first point that yes, an employee of a commercial registered agent, once they hit the 10 filing point, would need to file, but not a direct employee. Thank you.
Thanks. And in the gist of Senator Scott's proposal, then help me again with where you come down on that.
Can you restate, Mr. Chairman, the entirety of that one?
Well, Senator Scott, I think basically, and I may have missed a turn here, but Senator Scott's saying they don't have to be third-party filers if they're already a commercial registered agent. Or a member of the bar,
Mr.
or
Chairman,
a CPA.
I'm personally not a big fan of exceptions for attorneys and accountants. I think, but that's more me as Secretary of State. I think that everybody should, if you're a person and you hit the cap, I don't think we should have exceptions. But
Okay,
that's my opinion.
Any other questions for Mr. Meyer? Representative Ottman.
Thank you, Mr. Chairman. Hello, Mr. Meyer. What I recall about this is that before the working group was established, there was some concern by Assessor Berg because there was like one entity that had registered over 100 different businesses and found that they couldn't really be tracked down. And with the idea of keeping with these filings and the privacy of the original entities, not the registered agent, but that I had asked about that and I said, well, how can you even find out who they are? And so this bill, I'm thinking was to address that. Do you see that, or do you think it does not?
Mr. Meyer.
Well, Mr. Chairman, Representative Ahmed, I would say that I guess I'm not sure how this is going to address that specific question. Understand that contrary to some of the reporting and things that I've seen out there, it is not illegal to have a Wyoming entity that has no business assets or does not even do business in Wyoming. And nor is it a crime for registered agents or frequent filers to file for multiple entities and to represent multiple businesses. And why is that? That's because, and I think Secretary Gray pointed out that because of our laws. People come here not because it's all a question of being, it's an anonymity, and it's not a question of how we can get away from stuff. It's how our laws deal with the formation of entities, how those entities are governed, how members or shareholders deal with each other and deal with the entity. It's how we deal with dissolution and how do we deal with liability issues. Those are all the reasons why the laws were revised in 2010 and 2009 to make sure that those are there. So I guess my answer to you, Representative, is that I'm not sure having a frequent filer identification of some sort of commercial filer really addresses those issues that were brought up in Lander by Ms. Berg.
Follow up, Representative Ottman.
Thank you, Mr. Chairman. I guess maybe I wasn't clear, Mr. Meyer. What I recall is that there was a registrar or information that there was a registrar that was at a vacant lot. And I agree that the LLC laws and all of those are wonderful, and that is a good thing that we do here in Wyoming. But when I ask, well, how do you find out if these people really exist? It's like, well, not until there's a report or an investigation or somebody is suspicious. And so I believe that the intent of this could be to address that issue, not to do anything against the wonderful laws that we have concerning the LLCs, but just to help identify anybody that could be doing things that are not legit.
And just to weigh in a little bit, I think that vacant lot was my lot.
Yeah.
And I think the filing was that was the business address, not the registered agent's address. So I think they know the registered agent's address by and large. And there are companies that don't have just hundreds, they have thousands of people that work for them. But to you, Mr. Meyer, to follow up.
Well, thank you, Mr. Chairman and Representative Alman. I would tell you that I would agree with the chairman that you have these entities, and everybody does know. I mean, you're required to identify the registered agent and that registered agent's address. And so I think that having that information as to commercial registered agent probably would highlight quite a bit of here's what's going on with the little house on the prairie or the building that's in Sheridan or whatever that seems to be caught in a lot of attention. At least in my opinion, I'm not sure letting people know that I have filed more than 10 entities or somebody that's out there in the boondocks of Fremont County has filed more than 10 entities. If the objective is to make sure we have a real person out there that's actually doing this stuff, then I'm not sure what, we can play games with that all day long and I can get more people to be my employees or whatever and be the real person that they're trying to do to file that. I'm just not sure. I guess I'm just not convinced yet that having a list of all the people that file more than 10 entities will in fact address an issue of fraud with respect to what was being addressed here.
Thank you. Any other committee members, questions for Mr. Meyer at this time? Because I'd like to go to Mr. Weaver too. So anybody? Let's go to Mr. Weaver.
Thank you, Mr. Chairman. Good afternoon or good morning still to the committee. I want to thank everyone who was involved in the working group. I think that my primary comment goes to the question that has already been raised by Senator Scott and others, which are if the goal of this particular bill is to make sure that we have that filers are real, actual, living, breathing human beings and not a creation of some fraud, then I would encourage the committee to entertain creating an exception for folks who are already known to the government of the state of Wyoming in another form or fashion. In particular, that would be attorneys and chartered accountants who are already known bona fide folks and who have gone through a very meaningful diligence process when their licenses are issued. I would think it would make sense to limit that to folks who are actually licensed to practice within the state, so that if attorneys who are licensed elsewhere would like to use Wyoming entities as has been described, they're free to do so, but they would need to organize. I recall, taking Mr. Meyer's comments, I recalled at the outset that there were some questions from Secretary Gray and his staff as to whether or not organizers were actually natural persons, and I understand, and perhaps Mr. Secretary could speak to this, that there were some folks where they had trouble verifying their identities. And so if that is something that we think is an issue, then I think this bill addresses it. But I'm also aligned with Mr. Meyer that information on the organizer, typically a commercial organizer forms the business entity on behalf of the shareholders or members, and then has no further ongoing relationship with that business entity once it has, management has taken over control. So I do think that this would give, the Secretary of State's office additional information, but as soon as that entity is organized, then that organizer steps away and they have no further role. So if we're trying to solve for Ms. Berg's concerns about, ongoing contact for things like tax reporting, then I'm not sure that this does get a lot of traction in addressing that concern. Thank you, Mr. Chairman. I'll stand for questions.
Questions for Mr. Weaver? Any questions for Mr. Weaver? Not seeing any, but thank you, Mr. Weaver. We'll go around the table one more time. Mr. Secretary, did you want to respond to any of that or stand on what you said before? That's great. Thank you. So committee, we've heard from the working group. Senator Scott, I see your hands up. Let's go to you.
Yeah, Mr. Chairman, question I think probably best directed at the Secretary of State's office on when you look at the bill on page 2, lines 4 and 5, this is people who wouldn't be required to register, not a direct employee, shareholder, director, etc. Am I right in thinking with this language, somebody who wanted to create a bunch of corporations that they could essentially have on the shelf and sell as necessary would simply be the original shareholder, and what they would sell would be all their shares in the corporation eventually, and they could do it at any time after they got filed, and this exemption would apply to them, and you wouldn't necessarily know anything about them and enough to make sure. And I'm not sure that the way it's written, the shareholder would have to even be a real person, could be another corporation. So I wonder what the effect of that provision. I see the need for a provision like that, but I'm wondering the way it's written as to how effective it's going to make the bill.
And Senator Scott, if you don't mind, give the reference, the statutory reference again.
It's on page 2, lines, essentially, it's subsection A of the bill, but particularly concentrating on lines 4, 5, and 6.
Thank you very much. And we'll go to Mr. Rubino. Thank you, Mr. Rubino.
Thank you, Mr. Chairman and Senator Scott. If I'm understanding you correctly, on page 2, lines 4 and 5, you're talking about the existing exception for those that are not a direct employee shareholder, and you're getting it shareholder or member. I think although I can't speak on behalf of any commercial registered agents or commercial organizers, which is really what the intent of this bill is intended to address. That's really a question of liability and well settled, principles of corporate law that does not hold organizers liable for any actions or omissions of an entity, whether that be a corporation, a limited liability company, or other business entity. And so, again, although I don't speak on behalf of commercial organizers, I think that they would be very hesitant to do that, albeit for a very brief period of time, because for that brief period of time, they would be then liable for any acts or omissions of the corporation. And then there may be a question, depending on the time that an act or omission occurred, of when they were, even if it was only for a very short period of time. And so that's, I think, what gets at that. I think they'd be hard pressed to go through that order of operations in order to get around this, if that makes sense.
Back to you, Senator Scott.
Mr. Chairman, the answer tells me that I flatly do not understand the purpose of subsection A, because I didn't see it as having any liability implications one way or the other. So I will confess at this point, Mr. Chairman, I don't understand the bill.
Thanks a lot, Senator Scott. No, we do appreciate it. Thank you. We'll try to work this stuff out. Mr. Rubino, do you want to try a different way? Don't have to.
Mr. Chairman, Senator Scott, and I think all that is getting at is that if they're a direct employee, shareholder, director, they're already caught within the realm of someone who's acting on behalf of the business. What this bill is really intended to go after are the third-party organizer mills that we see, and we're seeing allegations or accusations that there are not real people, for lack of a better word, that are acting as the organizers. But what we've seen in the allegations we've heard is not so much that real people are in fact the shareholders or the members or the directors or things like that, or employees. I think that's a different situation.
Okay. Senator Scott, I see your hands up.
Yeah, Mr. Chairman, my thought is, though, that somebody who was in the business of creating these entities in order to sell them would file them when he was a shareholder, and then would turn around and when he's ready to sell, would be simply sell all his shares to whoever he was selling the corporation to. And especially if the shareholder was another corporation, which I think would be possible under this, you would simply have a way that somebody that wanted to get around this third-party filer provision could in fact do it. And that I see where you've got a corporation that's going to function in this state or some other state. Having this exemption is a good thing, but I'm afraid the exemption also negates the bill. And maybe I just don't understand exactly the mechanisms involved in subsection A.
Well, I think you're onto something, Senator Scott. Why don't we hear from the other members of the working group if they want to weigh in, don't have to? Anybody want to weigh in? Turn on your mic if you do. Shaking head on Weaver. How about you, Mr. Co-Chairman? Any thoughts?
Mr. Co-Chairman, I think that Senator Scott, his theory, I guess, or his hypothetical situation that he proposes is definitely within the way the construct of the bill is. you could definitely do what he's talking about. If a person wanted to create a bunch of entities, put them on the shelf and sell them, they would get around it. I think Mr. Rubino's point of liability is what would keep most actors from doing that. I'm not sure, Senator Scott, if you heard that, but I do think that's a big factor in somebody shelving a bunch of companies, because they're creating liability, and they're creating a nexus of liability, being a part of the company, as opposed to being an organizer. Being an organizer only, even if you're an attorney or an accountant or whoever you are, you're indemnified from liability for companies that you organize, and then hand over basically to the people who are going to run the company. So that's the reason why you would see that used very seldomly, I think. And in my personal opinion, Mr. Co-Chairman, would be that if we were to enact this bill and we somehow discovered that there were entities being created under that hypothetical that Senator Scott's proposing, I think we could find a different way to address it. But I just don't think it doesn't seem like that's really going to happen. I think that's a pretty far stretched hypothetical, in my opinion.
Thank you, Mr. Co-Chairman. So it kind of strikes me that, if you're forming a shell corporation to sell it, but you're actually the shareholder, you come under all the other business laws we have in Wyoming. I mean, there is a nexus, and we have a connection there that we can, if needed, pursue. That's different than someone that's just signing the paperwork. So let's keep moving. Any other questions on the bill? Representative Newsom.
So a question for the secretary or his staff. Thank you, Mr. Chairman. I guess, what is the process as we met in April in Lander, and the assessor brought those fraudulent filings from Fremont County? What's your process as someone would put an application in? Do you verify any addresses? Do you do anything, or do you just say, okay, you're good to go? What's that process at this point?
Who wants to take that? Mr. Secretary, thank you.
Well, Mr. Chairman, as we discussed in the intro, we started a process in 2023 of when there is a verifiable fraudulent filing for somebody to attest to that, file an affidavit with our office. This is really a process that we don't have a record of our predecessors really doing, and dissolving those entities, which we did on many of the entities that Assessor Berg has identified. I think there's been a little bit of confusion with some of, the media reporting on Assessor Berg's points. A lot of those addresses are at CRAs, which is totally legal. And so if we want to go deeper into that, that's certainly something we could do. But I think even Assessor Berg, and I don't want to speak for her, but at the working group did not bring that proposal.
Mr. Secretary, if you wouldn't mind, define CRA.
Certified registered agent, commercial registered agent.
Okay,
yes.
thank you.
And so, but I think that procedure we've instituted, Assessor Berg submitted a couple things to our office, and we dissolved those entities. And so we've also actually met with the county treasurers, the county assessors, sent them a letter laying out this procedure as well. That's another thing we did that I wanted to talk a little bit about.
And then Representative Newsom, we have other bills on our list here that get at the overall problem. And so, Mr. Co-Chairman.
Just one more thing for Representative Newsom, because I don't think this was adequately discussed at our last meeting, but hopefully it's clear to the committee that there's the fraudulent acts that Assessor Berg has outlined for us, but then there are also the ones that the secretary is referring to where you list a commercial registered agent. That's really critical to, it might sound a little odd, but in our statutes, there is absolutely zero requirement to list an address for your business when you create one. When you create an LLC, there's no legal requirement to list an address in the state of Wyoming. So what a lot of companies do when they form is they pay a registered agent and they use that registered agent's address, which is perfectly legal. Something that Secretary of State just pointed out, that's something that we have not chosen to address as the working group. But a lot of Assessor Berg's examples that weren't fraudulent were just, they seemed confusing because that's the law is actually permissible in listing a registered agent because you're not required to have an address at all in the state of Wyoming.
Okay, any other questions? We're at the point, let's hear if there's any other public comment on the bill. Remember I see Mr. Pope is here. Welcome, Mr. Pope. We've just gone through the first bill and the committee, we're looking at these bills with the idea that we're not approving the bills for final passage today. We are carrying the bills over to the next meeting. So that would be an affirmative motion would do that because it hasn't been in the public domain long enough for us. And the committee's seeing these bills for the first time. So right now we're discussing 25 LSO 0114, third-party filers. We've actually had testimony on the bill and had it presented. We've heard from Mr. Weaver and Mr. Meyer. We certainly let you weigh in, but we have kind of finished talking about that one.
Thank you, Senator.
Mr. Pope.
Thank you, Senator and Mr. Chairman. I appreciate this opportunity, and I don't have any additional comments on this. I apologize for being a little late. I was interviewing candidates for the Stable Token Commission, one of the jobs posted there. So I will be available and here for the rest of the testimony on the remaining topics here, though.
Thank you very much. So let's hear if there's any other public comment. Are you aware of any online? Is there any in the room? So, Mr. Alwood, were you trying to raise your hand? I'm sorry, I'm paying close attention to the people in the room. So it doesn't look like we have any public comment. The question would be, should we carry this bill forward to the next meeting or should we dispose of it now? So anybody want to move to carry it forward to the next meeting?
Mr. Co-Chairman.
I'll
I'll move to carry it forward, but I would like to see an amendment to the draft that provides an exemption for Wyoming licensed attorneys and accountants.
Okay, let's do two things. Second to I had people wanting first, so it's on the table. Why don't you make the motion?
And then I'll make the motion.
About the amendment.
Okay, yeah, I'll move to amend it to include an exception for Wyoming licensed attorneys and Wyoming licensed accountants.
Senator Scott, I assume you'd give him a second. I'm going to give it to you. That was your issue, one of your issues.
Yes, Mr.
Discussion.
Chairman.
All those in favor of having to amend this draft to exclude, it's not to have an amendment drafted. It's actually to look, next time we see the draft, it'll have the amendment in it to exclude legally Wyoming licensed CPAs and legal members of the bar. So that's the amendment. Now, does that include public accountants? Is there an issue with that or not? Public accountants versus certified public accountants? I don't know if that makes a difference, but we'll leave it at certified public accountants for now. All those in favor signify by saying aye. Any opposed? That motion, I got a no over here on the left, but it sounds like there's more ayes. Senator Scott.
Mr. Chairman, I would also move that the bill include an appropriation as per the Secretary of State's office, and that it be worded in such a way that the filing doesn't have to start taking place until after January 1st, but they can do the preliminary work getting ready, including the modification of the computer system before then.
Okay, is there a second to that motion for the appropriations? I think did you say 100,000? What did you say, Senator Scott?
Mr. Chairman, whatever the Secretary of State said
think-
it was gonna cost.
I think you said up to 80, but you'd like a little cushion. Could we just say 100,000?
Fine.
Okay, we have it at 100,000, going once, going twice, and with a second by Wiley. Discussion. Do you understand the concept of the amendment? Got it? Okay, all those in favor signify by saying aye. Any
Aye.
opposed? That amendment's carried. Anything else?
Mr. Chairman.
Representative Yen.
Mr. Chairman, on page 4 of the bill, I'd like to strike the maximum cap for the filing fee. And if I have a second, I'll explain.
Okay. Somebody give the gentleman a second? Got a second by Newsom? Go ahead.
Mr. Chairman, so I was actually looking up what the filing fee for registered agents are. And in statute, it's actually explicitly designated to give it to the Secretary of State by rule. And so the filing fees are set by rule by the Secretary of State. I could not find an upper limit for the registered agent for that. So I figured if we want to make them streamlined across between this and the registered agent statute, we just don't have a cap for it in here either.
So how exactly would it read?
Mr. Chairman, on page 4, it would read, the fee shall be designed to recover the cost of administering the provisions of this section relating to third-party filers.
Period. Okay. So it eliminates the reference to the fee at all. Discussion. Any discussion? You ready for the question? All those in favor of Representative Yen's motion to eliminate the reference to the fee, signify by saying aye.
Aye.
Any opposed? No.
No.
I'm a no. Let's have show of hands then. All those in favor, raise your hand. 1, 2, 3. Are you in favor? 4, 5. I'm getting 6. All those opposed? Getting 1, 2, 3, 4, 5, 6, 7. It's failed. Anything else on the bill? Anything else on the bill? All those in favor of moving this bill over to October meeting signify by saying aye.
Aye.
Any
Aye.
opposed? I think we got a couple opposed up there, but it looks like it's carried over to October. We still got about 15 minutes. Would it be possible to present the next bill? And then we'll take a lunch break and then come back. And the next bill is 25 LSO 115.
Mr. Chairman, this is 25 LSO 0115, working draft 0.4, providing false information to registered agents. And so what this bill generally does is it amends the grounds for administrative dissolution, revocation, and forfeiture to include providing false or fraudulent information to the registered agent. If you turn to page 2, Section 17, 16, 14, 20 provides grounds for administrative dissolution of corporations. So subsection A provides that the Secretary of State may commence a proceeding under section 17, 16, 14, 21 to administratively dissolve a corporation if any of the following has occurred. Paragraph 6 provides that it is in the public interest and the corporation, and then there's a list of subparagraphs. So this would be adding in a new subparagraph D that's at the top of page 3, which would provide that if the corporation has provided false or fraudulent information to the registered agent as determined by the Secretary of State during or following an examination of records pursuant to section 1728-108 or following notification by the registered agent. What the rest of the bill does is it carries that same provision into other business entity statutes. So we have the identical language in those other statutes. So I'm going to direct your attention to page 9, and there's a staff comment. And so for reference, the statutes regarding registered agents apply to business entities. And then there's a definition of business entities that's in those statutes. And so what we did is we went through and tried to find all of these provisions that provide the Secretary of State that similar type of administrative ability to dissolve or terminate these business entities. And so this bill draft directly amends the statutes that govern the first set of entities that are listed. So we have domestic and foreign corporations, domestic and foreign nonprofit corporations, limited liability companies, and statutory foundations. And then in addition, there are statutes that cross-reference these statutes that are directly amended. And those include domestic and foreign cooperative marketing associations, foreign limited liability partnerships, foreign statutory trust companies, and foreign limited liability companies. As noted at the bottom of the staff comment on page 10, LSO didn't locate any other statutes that grant the Secretary of State this similar type of broad administrative dissolution, revocation, or forfeiture authority. And the act would be effective July 1st, 2025. And with that, I would stand for any questions.
Thank you. Questions for Ms. Adams? Questions for Ms. Adams? Okay, we got some time. Would the Secretary of State like to address it?
Thank you, Mr. Chairman. We are very excited about this bill draft. Is another concept we presented to the working group, and really appreciate the working group bringing this to the entire committee. As written, it would add another tool to our toolkit in both identifying and taking action to administratively dissolve business entities if we are notified that the business entity has provided false or fraudulent information to its registered agent. From a high level, I think this bill is not only necessary, but in our conversations with some commercial registered agents, is something that would be highly beneficial to the registered agent community. As a little background, business entities that employ a registered agent are required to provide the registered agent certain contact information, which may be audited by our office. Under our administration, our office has increased these audits of commercial registered agents, checking for compliance by the commercial registered agent and keeping this information. However, our office does not have the power to take any action against the underlying entity if the underlying entity is providing false or fraudulent information to the registered agent to begin with. Essentially, the trigger for administrative dissolution under the bill would occur in two instances. One, during an audit of a commercial registered agent, if we determine that an entity has filed false or fraudulent information to the registered agent, or two, if we are notified by the registered agent that a business entity has filed false or fraudulent information with the registered agent. This bill does not on its face have any fiscal impact on our office, but would be utilized by our business division to ensure the integrity of documents filed with our office and that may be audited by our office. I do want to note that because of our ramp up on audits of commercial registered agents, it's part of our request to the Appropriations Committee in terms of a modest increase in staffing in the business division, which basically was also our request in the last budget session, but that is separate from this bill, to be clear. Thank you.
Thank you, Mr. Secretary. Questions for Mr. Secretary? Representative Yen.
Mr. Chairman, thank you. Mr. Secretary, I do appreciate the bill draft. I think it's fine. But I wonder why B by itself, the capital B by itself, is not enough. I mean, I think it provides some cover for our registered agents, but it's still the corporation has provided, it reads as the corporation has provided fraudulent information or has failed to correct false information. So that still is the same thing, right? So they still have provided false or fraudulent information. It's just.
And Representative Yen, did you say D as in David?
B, the capital B. So it's on page 2, line 15 through 18.
That's existing language.
In existing language. So my question is, why is the existing language not enough, and why do we need the bill instead? Because I actually argued in our April meeting that you should be dissolving a lot of those LLCs because of the existing language, that language B.
Mr. Secretary.
Mr. Chairman, if I can address that.
Oh, certainly, Mr. Rubino.
Representative Yin, I understand your point. And I think it's a reading of the bill, but under my reading of the bill, and I can have Mr. Crossman elaborate on how our audits work, the underlying entities don't file that information with our office. So when we do what we've done and over the past year is ramped up the number of especially in-person complete audits where an individual from our office, typically Mr. Crossman or our deputy, shows up, which is allowed under statute, to the office of the commercial registered agent and says, You're required to keep this information. We'd like to take a look at it. Existing statute allows that under the Commercial Registered Agent Act. But that information, unless it's, well, that information is not filed with our office. It can be obtained by our office upon an audit, whether it be a spot audit or an in-person complete audit, but it's not filed with our office. And so I understand your reading, and I think it's certainly I understand your reading, but I don't know. I think that might be a stretch to say that that could be used to then dissolve the underlying entity. I think you'd run into legal issues with that.
I think I get your point.
Mr. Chairman, thank you. I think
Representative Yen.
I appreciate that. I think that actually, I understand your explanation. I think you're saying that it actually allows for broader policing of the corporation, because it's not necessarily information that's filed with the Secretary of State, but information that's actually given to the registered agent that is also covered as a reason to administratively dissolve.
Bingo.
Thank you.
Good job. Thank you. Any other questions for the committee? If at this time, I know that, okay, let's go to Senator Barlow, and then I want to get, before we go to lunch, I want to hear from Mr. Meyer, because Gus Fleshley's reception is today. So Mr. Barlow, Senator Barlow.
Mr. Chairman, I can wait till after lunch. Thank you.
Are you sure? Okay, Mr. Meyer, I wanted to give you the opportunity.
Well, thank you, Mr. Chairman. I really not, I guess I think that the Secretary of State already has authority for to administrative dissolve entities to provide false information, but having listened to the discussion regarding with Representative Yin and Secretary Gray, if that makes things a little easier or gives a little bit more teeth to the Secretary of State, I don't have any objection.
Yeah. Thank you, Mr. Meyer. And if I know you're not going to be available when we come back from lunch. And so are there any other comments you'd like to make on the other bills? We'd give you that opportunity since you were a member of the working group.
Mr. Chairman, I think the only one that I have any heartburn over, it's just one of these things that there's just something in the back of my head, but the ability regarding the foreign entities, adversary ownership and control of businesses. I know that the LSO put together a very fine memo that talks about the conflict of laws, and I enjoyed reading that, and I think that they're spot on. I'm not sure how that would really work, and I do think that there may be a constitutional question in there of what we can do as to, I don't know that any of these necessarily states are trying to do stuff, whether it's China, North Korea, or Russia, or whatever. But I do think that they probably have people there, but I don't know how you're going to separate that. And I do think that there may be a problem. So I think personally, I just think it'll be very hard to enforce. And I don't know how the Secretary of State's office will determine ownership, but I will leave that to them. Other than the cancellation of registration for trademarks and trade names, I personally have not ever seen too much of a problem with this. However, I would be curious as to what is needed and why, but I'm certainly not going to be opposed to that. Because I have no idea how where that issue comes. So.
Thanks. I think we're not going to engage in that discussion right now. We are going to go to lunch. I appreciate everybody's participation. We have a scheduled lunch till 1:30, but we will start promptly at 1:30 to finish this topic up. We've got this bill and a couple more. So with that, we're going to take a recess until 1:30.
Nap.
I think he's still in minerals.